Hello and welcome to Trial TV Live. I am the Squeegee of Justice. Thank you so much for joining us. We are in Verdict Watch Day 2 of Zarrius Hildabrand. Appreciate you guys joining us. Hopefully we will have a verdict today. So let's get comfortable and let's get settled in. All right, welcome in everybody. Welcome in. Hope everyone is doing okay. Let's see. How is everybody doing today? We are in we're in Verdict Watch, and we're in day 2 of Verdict Watch. Horse Welfare, how are you? Good vibes. Good to see you. Definitely do not want to do that. Sorry guys, we are dual streaming, and I'm just a little out of sorts here. Let me get myself sorted out. Carol, how are you? Good to see you. William, good to see you. Aussie, hello. Allison, welcome in. Kathy, hello, hello. YT Hazel, Brett, Downey Lynn, good to see you. Snap, Missy Russell, welcome in. Debbie, how are you? Good to see you. Debbie, we are definitely feeling better. Thank you. Appreciate that. Leroy, Shadow, how are you? Come on, guys. Come on. Gracie, how are you? Hey, Dawn. Good to see you. All right. Jenny G, welcome in. Iowa Backyard Cam. Kimbers, how are you? All right. So we're in Verdict Watch here, day 2. I'm going to officially start the clock because they are supposed to be... They're supposed to be there now at 8:30 their time, so I'm going to go ahead and start it now, and we're just going to kind of be winging it. So nothing is official at this point, but we're just going to kind of be winging it. All right. My main focus is going to be at the Blaze Taylor trial, which we're dual streaming, but I will go ahead and put on something here to watch while we do that. I want to watch the medical examiner again. I think that'll be good testimony. So let me put this on over here, and we'll watch this over here. All right. Why is that? Oh, because it's there. Okay, hold on a sec. Get this sorted out for you guys. All right. Okay. I had no idea this was so blown out. Sorry, guys. Let me just sort that out. Okay, There we go. Hello, Super Ball. How are you? Yeah, good girl. Okay, you have to move so I can get the stream going. Thank you very much. All right. Let's do that. Verdict watch is on. All right, so this is the medical examiner from day 5.
Doctor, I'm going to have you introduce yourself to the jury and tell them what you do for a living.
Hi, I'm Dr. Gallagher. I'm from the Alaska State Medical Examiner's Office. Become a forensic pathologist. I completed medical school at The Ohio State University after undergraduate school at Eastern Washington University. Following medical school, I did residency and fellowship in forensic pathology and general pathology. After residency at Ball Memorial Hospital, I did my fellowship at the Hennepin County Medical Examiner's Office in Minneapolis, Minnesota. I also did a fellowship in cytopathology at the University of Mississippi in Jackson, Mississippi. Following residency and fellowship, we complete our board certification through the American Board of Pathology in anatomic pathology, which is the study of tissues, the clinical pathology, which is the study of blood work, forensic pathology, which is the study ultimately of determining the cause and manner of death in cases of unattended death, and by that I mean death that's not otherwise expected or followed by a physician that falls under our jurisdiction for review. Following the board certification process, we do a continual maintenance of board certification through quarterly questions with the American Board of Pathology, as well as yearly continuing medical education requirements that are performed throughout the year.
And how long have you been board certified in forensic pathology?
Since I started here in 2013, but board certification was in 2008.
Okay. And where did you work before you worked at the Alaska State Medical Examiner's Office?
I was I did general pathology for 4 years there at Grant County Hospital in Grant County, Indiana, followed by 3 years of forensic pathology as a medical examiner at the King County Medical Examiner's Office in Seattle, Washington. And then I've been here since 2013, December.
Okay, so total years conducting autopsies, how long would you say?
20.
And in that time, have you been qualified as an expert in the field of forensic pathology?
Yes.
In what states?
Indiana, and Washington State, and Alaska.
Okay. More times than you can count?
Yes.
Okay. At this point, Judge, I would offer Dr. Gallagher as an expert in the field of forensic pathology.
Any objection?
No, Judge.
He's so qualified.
Can I have you start by explaining to the jury, I guess, the role of the forensic pathologist or the medical examiner in a death investigation?
Yes, so when we get notified that there's a death, information's passed along to us to determine whether it's going to be a jurisdiction, that a case that we take jurisdiction on. The information goes to our medical legal death investigators at the office. Following a case being accepted as our jurisdiction, we have different levels of exams. Sometimes we'll not need to bring the person in, and we'll be able to review their medical history records and certify the cause and manner of death on the death certificate. Other cases where we want to do a limited exam, we'll bring them in. We'll do a full head-to-toe examination of the person, just noting any normal natural disease processes and or injuries. And then we'll take body fluids, blood, vitreous from the eye, urine. We'll send those out for toxicology studies, and then we'll review their medical history and determine their cause and manner of death. And then in other cases where we need to do a full internal autopsy examination, we'll bring them in and we will again do a head-to-toe examination. The first thing we do when we bring them in is we take a photograph of how they arrived in the office, the body bag that is closed, and then we'll take additional photographs, and then we'll take them out of the body bag. We'll remove clothing, take pictures before and after cleaning, and then in cases where evidence is collected, that evidence is collected prior to cleaning of the body, and then again, body fluids are taken for toxicology studies, and then we'll go ahead with an internal examination after our head-to-toe external examination, and we'll review all of their organs, brain, heart, lung, abdominal organs, and then we'll examine those for any natural diseases or injuries, and then those go into a report. Essentially, we wait for the toxicology studies to come back. Sometimes we do microscopic studies of the biopsies we take, and all of that information, it's put together in the autopsy report for the ultimate determination. Is what our office is charged with, is to determine a proper certification of the death as to the cause of death and the manner of death.
And when you say cause of death, what does that mean?
Cause of death would be the event or the finding that is the cause of death. If it's an accident, it might be a blunt force injury. If it's a natural disease process, it could be heart disease. It could be emphysema, lung disease, or whatever disease process that we find during our studies. That would be the cause of death, and that's the cause of the immediate death.
Okay, and then when you talk about manner of death, what are kind of the range? What's the options?
Manner of death, we have several to choose from. We have natural death, we have accidents, we have suicide, which is an injury to oneself, whether that's a traumatic injury from a blunt force, or an injury from a weapon, or if it's a intentional ingestion of too many drugs, that would all fall under the suicidal manner. And then we have homicide, which is an injury caused by another individual. And then we have undetermined is another classification that we can use sometimes when the manner is either overlapping or not totally clear, in that it lands in only one of those other options. Then we'll choose undetermined for cases like those.
And in this case, I kind of want to start with the bottom line and then work back through what you did. Were you able to determine a cause and manner of death for Saria Hildabrand?
Yes.
And what were those?
Her cause of death was a penetrating, indeterminate range gunshot wound of the head, and the manner of death that I certified was as a homicide.
Okay. You said indeterminate range. Indeterminate or intermediate?
Intermediate, sorry.
Okay. I'd put my glasses back on as well. So I want to talk with you a little bit about how you come to those conclusions. Does somebody from the medical examiner's office go out and observe and collect the body from the scene?
Depends on the jurisdiction where it happened. If it's outside of our physical response area, then the body will be collected by troopers or officials at the scene of that location. If it is within our jurisdiction, then one of our death investigators goes to the scene for securing the body and bringing them back to our office.
Okay, so a death in essentially a park in Anchorage.
That would be our response area.
And then you get involved the next morning?
It depends on when they get into the office, but after they're brought in to the office, typically the next business day, depending on the amount of cases that are at the examiner's office to do, they'll come up for the examination that we'll perform.
Okay. What was the date and time that you performed an autopsy on Saria Hildabrand?
Yes, if I refer to my report, on the first page, it was August 11 of 2023 where we did our exam.
Okay. And what time in the morning?
0700, basically 7:15 in the morning.
And what were your pathologic diagnoses? What did you observe about her?
Yes, so on the front page of my report, I always summarize everything. So she had the cause of death injury was a penetrating intermediate range gunshot wound of the head. So that was an entrance that entered on the forehead, and then it passed through the skin, through the bone, and into the brain, and then caused lots of injuries, the disruption and pulpification of the soft tissue of the brain, bleeding around the brain, bleeding within the parenchyma or the body of the brain, and then the trajectory was basically a front to back is the pathway, and then we did recover several fragments of the copper and lead colored metal projectile or bullet from our examination.
Okay, and I want to go through those things. You said there's an entrance wound, and what side of her forehead was that on?
It's just left of the midline. So the midline there, so on the left side of the forehead is the entrance wound.
Okay, and when you say a penetrating wound, does that mean there was or was not an exit wound?
A penetrating wound is one where we'll be able to recover a fragment or fragments of the bullet. So if it's a perforating wound, typically there's an entrance, there's a nice exit, and oftentimes there's no remaining material that we can collect from the bullet.
Okay, but this was penetrating, so there were bullet fragments that remained?
Yes.
And without a clear, defined exit wound?
Yes.
Okay. And you talked about the injuries to her brain, the hemorrhage, the pulpification of the brain tissue along the wound pathway. Was there subarachnoid hemorrhaging throughout the entirety of her brain?
Yes.
And based on those injuries that you observed, is this a gunshot that would have essentially incapacitated or killed her instantly?
Yes.
Okay. She wouldn't have been able to move on her own after that?
No.
Okay. And you talked about photographs. Do you take photographs as well as the Anchorage Police Department?
Yes.
Okay. And is it common for someone from the crime scene team to respond?
During the autopsy?
Yes.
Typically, yes. Not always, but depends on their circumstances or their staffing.
Okay. But your office takes photographs as well?
Yes.
Okay. I'm going to show you what I have marked for identification and provided to counsel in the court as State's Exhibits 260 through 265. Go ahead and take a look at those and let me know when you're done. Okay. Do those fairly and accurately depict the injuries to Miss Hildabrand, the x-ray that was taken, and the fragments that were removed from her brain and skull?
Yes.
Okay, I'd move at this point for the admission of 260 to 265.
Any objection?
We maintain our previous objection.
I'm sorry.
I said we maintain our previous.
All right. Overruled. They're admitted. You may
Clerk, can I have you turn down the lights? And the first two photographs, is it fair to say that these do show her injuries?
Yes.
Okay. And When you're taking photographs, do you actually take sometimes dozens, if not hundreds?
Yes.
Okay. So this is really limited to just show the injuries relative to her death?
Yes.
Okay. So, what does 260 depict?
This is a photograph of the left side of the decedent here. She is looking up towards the ceiling, and then you have some defects there in the skin, surrounded by some bruising. If you have a great.
I'm going to give you the laser pointer's the red button on top.
Okay. So here you have the defect of the skin. This is the entrance wound itself. There's a couple other defects here, and then those are consistent with potential partial exits of a fragmenting bullet. There is these dark areas of bruising around the areas of skin defect, and she also has what we call stippling marks that are noted around the wound.
Okay, and I want to talk with you about the stippling in just a minute, but let's kind of take this piece by piece. What you have called the entrance wound, how do you know that that's an entrance?
We have a defect here, which is the actual splitting of the skin as the projectile goes through. And then we have here you can see this red area that's kind of below and then kind of comes down here. That's abrasion. You can also see some of it up here and as well as there. So that's an abrasion margin, which is typical of an entrance gunshot wound, in that as the bullet goes into the skin stretches, and then the skin rubs the bullet as the bullet goes through, and it creates that margin of abrasion around it.
Okay, and then you identified the other two wounds as potentially being partial exit wounds. Is that based on the location of where fragments were recovered from, essentially?
Yes, it also is based on kind of the area on the skull where the fracture is, as well as the fragmentation of the bullet itself that we see during our examination. So when something exits the skin, typically, not in every case, but typically you won't see the abrasion margin I just described around the entrance wound, because as the fragment comes out, there's nothing on the outside of that skin, so it just kind of tents out, and then it splits from the inside out as the fragment leaves. And so the skin, as long as there's nothing pushed against it, will not develop an abrasion.
Okay, and I want to come back to the stippling in just a minute, but to kind of solidify that that's the entrance and exit, did you also peel back her scalp to show on the skull where the entrance and exit was?
Yes.
And is that depicted in State's Exhibit 261?
Yes.
So can you show the jury on here where the entrance is versus the exit?
So here the skin has been reflected forward over the face, so the scalp is been reflected forward. You can see a lot of this bleeding in the scalp. That's called subgaleal hemorrhage. And then here's the entrance site, which corresponds with that front defect that was seen on the previous picture. And so here you have an internally beveled skull fragment, which is, again, what you see during an entrance wound. And then you have a partially externally beveled here. So that's what we call kind of a keyhole type of a wound, where the bullet kind of comes in and begins to break apart, and then some of those fragments can go into the head and brain area, and then some of them will escape outward and then exit, which is what this looks to be consistent with, an externally beveled area of that wound. So it's a pretty unique and not too common entrance fracturing of the skull, and it depends. I mean, basically, it's just kind of at the angle where it's kind of coming in, and where the brain or the skull itself kind of folds away and goes backward, kind of creates that area where the keyhole type of a fracture is more likely.
So I want to go back to 260 and talk with you about stippling and what stippling is and where you observe it here.
Yeah, so stippling, we have different distances that we can determine on a gunshot wound. So if it's a contact wound, you will have just the abrasion margin that's around that bullet, and then there'll be some staining of that abrasion margin and the tissues underneath with dark soot from just the gunpowder burning and smoking as it leaves the gun. And then the rest of the skin is completely clear because everything at a contact wound enters the wound itself. And then you have a wound that's a little further away. We call those intermediate range wounds, and those are wounds that will have varying densities or varying dense areas to less dense areas of stippling. Stippling is small abrasions that happen to the skin as the unburned fragments of gunpowder strike the skin and fall away, and so those unburned fragments strike the skin and create these abrasions. And if you have a close range wound that's not contact, but it's a close range, you'll have a pretty dense pattern. So it'll be just kind of around the entrance wound, but it might be a centimeter or so wide if it's a near wound. If it's about 6 inches away or less, typically, you might see some of that soot staining right around a very dense area of stippling. And if it's even further away, then you'll get spread out areas of stippling, just the small pink spots that are happening on the skin as the gunpowder particles strike the skin. But it's too far away for any of the soot to get on the skin or into the tissues themselves. And so what you have here, and you can see right up here at the top of the forehead, is where these small little red spots start. And that goes all the way up. You can see it right there at the hairline, and then you can still see it down here at the hairline on the left side of the head in front of the left ear, and then wrapping around this eyebrow here. So that's the entire dimension. So all those small little red spots that you see are stippling marks from unburned particles of gunpowder that strike the skin. And those vary in distance depending on the gun, depending on the ammunition. If it's a typical handgun, you can see that, roughly within 2 foot, or maybe a little more than 2 foot. If it's a highly powerful round or a magnum round with extra gunpowder, might see that further out. If it's a rifle, you might see these stippling marks at even 3 feet or so. The best way to determine exactly how far that is away from in a particular gun is to test that gun in the crime lab with the firearms expert with the same lot of ammunition that is suspected to have been involved with the actual injury. And so then they can determine the density and how far away something would be in their direct testing.
So it sounds like, based on your medical opinion, is this a contact wound?
No.
Okay. Clearly no, or?
Clearly.
Okay. And is that because there's no soot, no stippling right around the margin of that wound?
Yeah, this is a pretty broad pattern here. So I measured it in my autopsy report at 9 centimeters by 8 centimeters.
Okay. And you would expect that this photo in particular, several around it, might be used by the ballistics expert to get a a more accurate range?
Yes, and they could also review the measurement that was taken at the autopsy exam.
Okay. And what your finding is intermediate range gunshot wound, and generally where would you estimate that range to be?
Yeah, if it's a handgun, again, I would say 2 foot or so. And as it gets closer to the skin, this broad pattern would get closer and closer until it's, very dense near the entrance wound itself. But this is a broad pattern. So.
But certainly not contact.
Definitely.
And not close to contact.
No.
Okay. And does that help feed your diagnosis, or not your diagnosis, but your opinion about the manner of death?
Yes.
Okay, and that's why you say homicide as opposed to suicide?
Yes.
Okay. I want to talk with you. I'm going to move off the screen for just a moment. You talked, I think you clarified, but this is an injury that Saria would have died from immediately?
Yes.
Okay, she wouldn't have been moving on her own volition at all after this?
No.
Okay. Would you expect a large amount of blood from a wound like that?
It certainly can bleed heavily, yes.
Okay. So I want to talk with you a little bit about some of the other things on Saria's body. Did she have clothing and personal effects with her?
She did.
Okay, and you logged those on your report, right?
Let me double check my report. Yes, page 2, I have a description of the items that were received with her.
Did she have a wedding ring with her?
Looking on page 2 of my report. I don't see that I have written down. Doesn't mean it wasn't there. Sometimes they may be collected in other areas.
I'm not trying to trick you, Doctor. You didn't record a wedding ring?
I did not.
Okay. Did you record earrings?
I did.
No, nasal ring?
Yeah, she had number 7 of the report. I describe her right hoop-like earring, and then she had a nasal septum ring of the nose. So.
Okay, and she had a necklace?
And she did have a necklace, yes.
Okay. Underwear and a t-shirt?
Yes.
Okay. Did she appear, otherwise you said you did a full head to toe, did she appear otherwise healthy?
Yes.
Okay. And that includes a review of her organ systems, gastrointestinal tract, musculoskeletal system, etc.?
Yes.
Okay. You talked a little bit about toxicology. What did you take to send out for toxicology?
We sent on her NMS Laboratories is the laboratory that does our toxicology, and we sent them blood from the femoral vein, which is the leg area, as well as some heart blood and some fluid from the eye and some of the gastric content from the stomach.
Okay, and did they return a blood alcohol concentration back to you?
Objection.
Approach, please.
Okay. What was her blood alcohol content?
Yeah, she had a blood alcohol content of 0.048 grams per milliliter, which is below the alcohol intoxication of 0.08 that they typically say for intoxication of drivers.
Okay. So 0.048, and I want to talk with you a little bit about this. When somebody dies, does their blood alcohol content either stop rising or stop dissipating, or will it continue to rise or continue to dissipate?
It can rise somewhat as decomposition begins, so a small amount of that alcohol can be seen in patients that have advancing decomposition. Typically, it's a pretty a small number. Like I think things of 0.01 to 0.02 or so, or maybe a little more than that, can be from or can be directly from decomposition.
Okay. But other than that, it's fairly static.
Yeah.
Okay. Even if somebody was, say, deceased for days before you took that blood?
Yeah.
Okay. And I want to talk with you just a little bit about the items that were retrieved from Ms. Hildabrand. What is State's Exhibit 262?
This is a X-ray that we take prior to the internal examination.
Okay. And can you show the jury on the X-ray where the bullet fragments were recovered from?
Yeah, I don't know if we can dim the light a little bit. But,
Thank you, Madam Clerk.
So this is the AP X-ray of the head, so it's front to back, and we can see a lot of these white dense fragments. They're metal fragment, metal density fragments on X-ray, and we can see one here as well. And so these are metal fragments of the projectile that were recovered.
Okay. And then are the next three photographs, 63, 64, and 65, images of those fragments that were removed from her brain and skull?
Yeah, they are. And I just wanted to point out that this up here is a zipper from the body bag, so you can. That's not it's not a part of the projectile that we recovered. So
okay. You can also see the metal on her necklace as well. Okay. And I guess just for process, X-ray is something that happens to everybody when they come in, and that just happens while they're still inside of a body bag?
Yeah, it depends on the case, but in this case, yes.
Okay. And then what is 263?
This is a fragment of likely jacket material from the bullet as it breaks apart as it was going in through the skull. So, and this is recovered on the left front of the skull. So basically the entrance wound is there, the fracture is there, and we recovered this piece from that skull area.
Okay, and you're pointing to an area that is between essentially the left front of the skull and the temple?
Yes.
And then what is 264?
These are just additional fragments that were recovered on dissection of the brain from, again, these are metal fragments of the bullet.
And then 265?
And this is another small fragment of, looks like lead core material of the bullet itself that was recovered from the left side of the brain. Left parietal is just the mid lobe of the brain between the frontal lobe and the occipital lobe, which is the front and back, so it's the left side.
And were each of those pieces of evidence collected and taken by the Anchorage Police Department crime scene team that was there with you at autopsy?
Yes, we log them in, and they have to sign them out, and then they ultimately take them and sign them back into the crime lab, and they do whatever they need to do.
And just to reiterate, if you can tell the jury one last time the cause and manner of death that you were able to make in this case.
Sure. Cause of the death was penetrating intermediate range gunshot wound of the head with the projectiles that we recovered there, and the manner of death as a homicide.
Okay. Thank you. I believe that's all the questions I have for you, Doctor.
Thank you. Counsel?
May we approach quickly then?
Yes. keep going.
Good morning, Dr. Gallagher.
Morning.
We've met before in the course of this case, correct?
Yes.
Okay. I'm going to just kind of jump in. I want to start a little bit, talking a little bit about your background. You're a doctor,
Yes.
and you've been a pathologist for 20 years, correct? Or more?
Yeah, I think finished my fellowship in 2004, so I guess 22 years.
And that fellowship was in pathology specifically.
Yeah, I did one forensic fellowship and one cytology fellowship.
And just so to refresh our recollection, what exactly is pathology?
That's the study of disease.
Okay, and how does it relate to death investigation?
What we're charged with is to examine a body in an unattended death that we need to determine for proper certification the cause and the manner of death. And so in these cases we will review the medical history, and we review the body, and depending on the case, an internal examination and documentation of any disease or injuries that are pertinent to the cause and the manner of death.
Okay, and in your studies to become a forensic pathologist, you went to medical school, and then you also had fellowships and residencies, correct?
Yes.
In the course of your education, did you have textbooks?
Yes.
And are you familiar with Spitz and Fisher's medical legal investigation of death?
Yes.
Specifically the guidelines for the application of pathology to crime investigation?
I know the textbook. So
You know the textbook?
Yeah.
Is it in its 5th edition?
I don't know what edition it's currently at.
Okay. And why do you know this textbook?
We just study it during our fellowship, and we refer to it as needed during our cases, as well as other texts in pathology.
Okay. And do you, in your continuing education, do you use Spitz and Fisher's medical legal investigation of death?
Continuing education, those are from conferences that are professional conferences, and then we review the questions that are sent to us by the Board of Pathology for review. So not specifically any textbook.
Okay.
Yeah.
But fair to say you're familiar with Spitz and Fisher's medical legal investigation of death?
Yes.
It's a reliable authority.
It's a common book in the field. Yes.
Would you say it's reliable?
I mean, everybody's got different opinions on things, but it's one of the main textbooks. So
yes.
Yes.
And it's published?
Yes.
Okay. If we could briefly approach Judge.
Yes,
Helger, I want to kind of move on now. I'm going to reference Spitz & Fisher's medical legal investigation of death throughout our conversation today. But I want to talk a little bit about your role. You're a medical examiner.
Yes.
For the state of Alaska.
Yes.
You're a busy guy.
Yes.
About how many autopsies would you estimate you do a year?
250 to 350.
250 to 350.
Yeah.
And so that's it. And I'm guessing you don't work every day of the week.
Yeah, 5 days a week. So typically, it depends, but 250 to 350 cases a year.
And so fair to say you've written a lot of reports as well.
Yes.
And you document your findings in your report.
Yes.
And you rely on your report when you're doing that many autopsies.
Yeah, I mean, when you rely on it for look back for recollection. Yeah, certainly. Depending on how long ago a case was.
It's an important aspect of your practice, fair to say.
Yeah.
And you understand that your report goes to various people, including the district attorney's office at times?
Yes.
Specifically in this case, your report was provided to the district attorney's office?
Yes.
And you understand it goes to defense counsel as well?
Yes. And
you make sure to be accurate when you're writing your report?
Every effort, yes.
Every effort. And there's a pretty big difference between an intermediate gunshot wound and an indeterminate gunshot wound. Is that fair to say?
Yes. Intermediate has the stippling. Indeterminate is something that doesn't have the stippling. And it may be further away. It may not be, depending on clothing that may have filtered out such the findings that would typically be seen on an intermediate. And
you've testified today that in your opinion, the gunshot wound that you observed on Mrs. Hildabrand was an intermediate gunshot wound, correct?
Yes.
And fair to say, when you authored your reports, you did not consistently refer to the gunshot wound as an intermediate gunshot wound.
It is an intermediate range wound, but in the third page of the report, after head and neck, the head of that paragraph says penetrating indeterminate range gunshot wound. That is an error.
That's an error.
Yes.
Okay. And I want to talk to you a little bit more about some of the information. You noted when you were examining Mrs. Hildabrand that decomposition changes were noted, correct?
Yes.
And there's a process in death called levity with the blood pooling. Is that correct?
Lividity.
Lividity, thank you. And so can you tell the jury what lividity is?
Lividity is a settling of the blood after death. It doesn't pump around in the vessels anymore, and so if someone is laying down with their face up, then the blood will settle down, and the areas that are up will look paler, and then the areas that are below where the blood settles will look darker, because that's where the blood is settling.
Thank you. And did you note that process with Mrs. Hildabrand?
Looking at her report, page 2 is usually where I would put it. If it's something that is a significant finding to the exam, I'll put it in there. If it's not, I don't always put a specific comment to that effect.
Let me ask you this. About how long after someone passes away does it take for that process to occur?
Well, to begin, you might be able to start seeing it in a half hour or so, depending on blood loss. If there's more blood loss, then that ability to see that color differentiation as blood settles is limited because more blood loss has occurred. So, and then if you're a darker skinned individual, again, harder to identify those lividity changes as easily as a lighter skinned person.
Okay, thank you. And then I want to just follow up on some decompensation issues that might be present. So is it fair to say that decomposition can include the disintegration of blood vessels and spillage of decomposing blood, which may be mistaken for bruising?
Yeah, blood can leave the circulation as it gets hemolyzed. The blood will break down, and then if the tissues or capillaries in those areas, the hemolyzed blood can exit the bloodstream and get into those tissues, at which point those areas of lividity would become fixed, and you can't push them out. If you have a relatively fresh person with the lividity, and you push your thumb into the skin, the thumbprint will make the skin pale because that blood is still in the blood vessels at the time. And if it's after fixation, then you push on the skin and it won't change in color.
Thank you. And fair to say that somewhere between 36 to 48 hours into the decomposition process, the skin can start to look greenish or purplish?
Yes.
Thank you. And specifically for Mrs. Hildabrand, did you note that there was a green-gray decomposition-like change?
Yes.
On the neck.
I don't know where.
I direct the image too.
She definitely. What'd you say? Image?
Page 2.
Oh, page 2.
Paragraph and 2 under general description.
Yes. So. Yes.
And then you also noted gray and green marbling type of decomposition type change noted to the skin of the face, neck, and upper chest, correct?
Yes.
Thank you. So I want to talk to you again about the manner of death. That's important in your profession.
Yes.
Essentially, when you were doing an autopsy as a medical examiner, you determine cause of death.
Yes.
And you could determine manner of death.
Yes.
And the cause of death is essentially the medical reason for the death, fair to say?
Yes.
And then the manner of death is more how this occurred.
Yes.
And in your profession, there are 5 potential manners of death.
Yes.
There's homicide.
Yes.
There's suicide.
Yes.
There's accident.
Yes.
There's natural causes.
Yes.
And essentially undetermined, unknown.
Yes.
And homicide, that is when you determine a death has been caused by another person, correct?
Yes.
It doesn't tell you, that doesn't mean, it doesn't tell you the mental state of the person. You're just saying it was caused by another person, correct?
Yes.
Suicide would be the intentional taking of one's own life, correct?
Yes.
And then accident could include taking one's own life, but not intentionally.
Yes.
And Natural causes is someone passes away from, say, a heart attack or something?
Yes, that would be a natural cause.
Okay, and then the undetermined would be you don't have enough information to make a decision?
Yes.
Okay. So I want to talk more about the manner of death in this case.
Yes.
And I want to talk to you a little bit more about Spitz and Fisher's medical legal investigation. If I may approach the witness.
Yes. Thank you.
I'm going to ask you to hold on to this. You can look at it, but I'm going to ask you to read from it. Yeah. So I want to clarify one small thing first. You talked about an intermediate gunshot, correct?
I did.
And fair to say that in your profession, gunshots can also be qualified as a contact shot, a close range shot, or a distance shot.
Yeah, I call them contact range, intermediate, or indeterminate. Distant, I don't really use that term because there's not always something that not being there, you don't know if that bullet may have gone through another intermediate object that would filter out the findings that would make it to the skin on someone. So if it went through a door, a window, or a wall, it might take those findings that would normally get to the skin off of the skin because of that intermediate object.
Okay, and so what I would ask you to do is I would direct you to the last page of the packet I approached you with, marked on the top left, 314. And I would just ask you, there is a highlighted portion of page 314. It'll be the last page of the packet I handed you.
Okay.
And I would ask you to read the highlighted portion following. The terminology most often used to describe the range of fire is as follows.
Right. So you have highlighted here on page 314 of this textbook, talks about contact shot when the weapon is fired with the muzzle in contact with the body. A close range shot is when gun smoke is deposited on the target, and distant shot when the muzzle to target distance exceeds the limits in which gun smoke is identifiable on the target.
So fair to say in your profession, the terminology contact shot, close range shot, and distance shot are used?
Contact range, close range. Again, our office doesn't use distant because of the possibility of intermediate objects, so we could just call those indeterminates and not distant.
But you do use contact shot and close range shot?
Yes.
And determining manner of death, and a gun is involved, one of the things that you're looking at is range of fire, correct?
Yes.
And range of fire would be defined as the distance from the muzzle of the gun to the object, correct?
Yes.
And for a close range shot, some circumstances, a close range shot could be ruled a homicide, correct?
Yes.
Some circumstances, a close range shot could be ruled a suicide.
Yes.
And in some circumstances, a close range shot could be ruled an accident.
Yes.
And I would direct you to page 356 of the packet I handed you. It's stapled.
Okay.
And again, this is from Spitz and Fitcher's medical legal investigation of death. If you were able, I'd ask you to read the highlighted portion starting on the bottom of page 356 and going into page 357.
Okay. On page 356, under homicide, suicide, or accident, it says distinction between homicide, suicide, or accident may be difficult and sometimes impossible, yet it is the first question asked by the investigator in every death involving a shooting. Certain criteria are used by pathologists to define the manner of death within a reasonable degree of medical certainty. Among these, evaluation of the range of fire is of the utmost importance.
Thank you. Do you agree with that?
I agree.
And next I want to direct you to page 363 of Spitz and Fitcher's medical legal investigation of death. In the packet I handed you, I would ask you to read the highlighted portion.
Yes, so they have a paragraph saying an accidental gunshot can be distinguished from a homicidal or suicidal injury only by the circumstances that surround the incident. It is the duty of the pathologist to confirm or dispute the account that was given of the incident based on his findings at the post-mortem examination of the victim, that is, to prove whether the injury is consistent with the manner in which it was said to have occurred. The availability of photographs and diagrams of the scene is helpful, but personal viewing of the scene gives a better perspective.
Thank you. And I want to start with the first sentence there. An accidental gunshot can be distinguished from a homicidal or suicidal injury only by the circumstance that surround the incident. Do you agree with that?
I would agree with that.
And do you agree that personal viewing of the scene gives a better perspective?
Well, we have our investigator review of the scene, photographs and circumstances portrayed by the investigating agency as well. So that's why we take photographs of the scene, and even when it's outside of our jurisdictional response period, then we'll have the troopers document and catalog the scene also.
Okay, so I guess the question I have for you, Dr. Gallagher, is the statement in this textbook, the availability of photographs and diagrams of the scene is helpful but personal viewing of the scene gives a better perspective. Do you agree with that?
We have our review of the scene by our medical legal death investigators. So,
and fair to say you personally were not at the scene in this
a
case.
personal review of the scene is a personal investigation by our office. It doesn't need to be visited by an individual in particular, because they're trained medical legal death investigators.
Okay. And I want to direct you now to page 313. It would be chapter 8, injury by gunfire. Not in the staple packet.
Okay.
And I want to just ask you to read into the record the highlighted portion of page 313 of Spitz and Fisher's medical legal investigation of death.
Yeah, it says accurate assessment of the range of fire requires test firing of the gun with the type of ammunition that was used in the shooting.
Do you agree with that?
I agree.
Thank you. Then I direct you to page 328.
Okay.
And I'd ask you to read the highlighted portion.
It says the approximate distance from which a close range shot was fired can be evaluated only by test firing the particular weapon using the same ammunition as used in the shooting case under consideration.
And do you agree with that?
I agree.
So I want to talk to you a little more about the way you determined the manner of death for Mrs. Hildabrand. You conducted an autopsy, correct?
Yes.
And there was an investigator involved in the case, correct?
Yeah, I don't have that information in front, but it's a scene of our local response, so we would have had an investigator respond.
Did you review the investigative findings in formulating your opinion in this case?
Yes.
Okay. And I want to talk about the main issue that you based your opinion on in coming to the manner of death. And is it fair to say that the main issue that you were looking at in determining the manner of death in this case was that it has nothing to do with the scene investigation, it's the injury, it is an intermediate range?
It is an intermediate range wound, and the location of the wound also is atypical for self-inflicted wound, and the distance from the gun to the decedent's injury on the head is at a distance that would make it difficult, if not impossible, for them to trigger that weapon themselves.
The distance. And the distance is the range of fire, correct?
Yes.
And in your opinion, it was 2 feet, at least?
It's again, the stippling that you see on a intermediate range wound, if a handgun is used, generally is 2 feet, 2.5 feet, and gets less as it gets closer. And as the closer the wound gets, the narrower that pattern of stippling becomes. And you have on page 328 of this report, there's a definition. There's actually a photograph of a closer intermediate range wound. That's a significant closer distance, much tighter pack of that abrasion compared to the one that we had in our own. But this particular pattern is something that to identify the exact distance from that weapon to cause a stippling pattern of that 9 by 8 centimeter needs to be and should be most accurately confirmed through testing at the crime lab for the firearms expert.
Thank you. So I just want to kind of follow up again. So fair to say that the main issue, the main basis for your determination that this was a homicide was that you determined that the injury to Mrs. Hildabrand's forehead was an intermediate range, correct?
It is an intermediate range, and we of course use our exam findings plus the investigative records from the scene, as well as the findings of the intermediate injuries to the head. All that comes together. It's a combination of the scene investigation findings as well as the autopsy findings.
Dr. Gallagher, like I said, we've met before, correct?
Yes.
We met in a Teams meeting a couple months ago. Mrs. Hurley was there.
Yes.
A gentleman named Mr. Stuart Rice was there, an investigator with the Public Defender
I
Agency.
don't recall all the people involved. I remember the meeting, yes.
Okay. And when we spoke, you were doing the best to tell the truth, correct?
Yes.
And you were relying on your experience as in the field of forensic pathology at that time.
Yes.
And you were familiar with the case that we're talking about today when we spoke a few months ago.
Yes.
Okay. And do you recall me asking the question, what facts did you rely on in the investigative reports to reach a conclusion that Mrs. Hildabrand's manner of death was a homicide? Do you recall me asking that question?
No.
Okay. Would it refresh your recollection to see a transcript of that?
Not really.
No? Okay. So you don't recall that conversation, what you said to them?
That question, no, I don't recall.
You don't recall saying, well, her main issue is that, and it's not, has nothing to do with the scene investigation, is the injury itself is an intermediate range. Do you recall making that statement?
No, but that's an accurate assessment of the wound itself, yes. So that means the gun was at distance from her head at the time of discharge. It doesn't have anything to do specifically with where that injury occurs, whether that's at one place or another.
Do you recall going on to say she's got a pattern of stippling gunpowder abrasions around the interest wound? So those are indicative of it depends on the weapon, of course, but typically a handgun would be, up to 2 feet away for that type of an injury to occur.
Yeah, that's reasonable.
You recall going on to say if it's a rifle, it can be 3 feet or more depending on the weapon and the ammunition. She had a 9 by 8 centimeter distribution of stippling pattern abrasion around the interest wound. So I can confirm that wound, it took place from a distance and is not a close contact wound.
Yeah, that's not a close contact wound. A distance, it's not on the skin. It's not slightly away from the skin, because that would be a close range. Typically that pattern is about a centimeter wide, and as it gets further away, that pattern begins to spread out as more distance occurs. So in this particular case, it's intermediate range, and it's fairly broad across her forehead to her left side of her ear area. That whole area around that is a pretty broad pattern of stippling. And to determine the distance of that particular weapon and that ammunition to create that pattern is best determined in the crime lab through a firearms expert testing that weapon and that ammunition.
And you have never done that, correct?
No.
And fair to say, if someone trained in ballistics had a different opinion as far as the range of the gunshot wound in this case, would you defer to that opinion?
Yes. I mean, they would have, they would have to do the testing to determine the distance of that gun at from the they would, I would defer to their expertise in setting up the testing, but it would be accurate to have a head-shaped diagram or head-shaped device with whatever they use for determining that pattern, so it's properly shaped to her typical skull. And so that would be something that they would have to set up in their own testing procedures. But that's the best way to determine precisely the distance that would create that same stipple pattern.
And while you are a forensic pathologist, you are not a ballistics expert, correct?
Correct.
And again, you agree that accurate assessment of the range of fire requires test firing of the gun with the type of ammunition that was used in the shooting.
Agreed.
And you recall, I want to take you back to that conversation that we had a few months ago. Do you recall me asking you the question, besides the stippling and your determination that this was an intermediate gunshot wound, what other facts were you relying on to determine that this was a homicide, classified as a homicide? Do you recall that question?
Not particularly, but we, all of our cases are signed out with review of the autopsy findings, toxicology findings, investigative findings, and medical histories if they're pertinent. All that's put together before the certification to determine the cause and the manner.
And you recall in that conversation responding to that question, well, certainly like you mentioned, where she was found is certainly an unusual location, but the main finding of a gunshot wound that is further away that an individual holding the gun should be able to accomplish on one's own self is a major factor in the determination of the manner. Do you recall making that statement?
I agree with that statement.
And I want to talk just a little more about a few other of your observations in the course of your autopsy in this case. Do you recall if you documented any defensive type wounds on Mrs. Hildabrand?
Let me double check my report. I don't recall offhand. I don't see that I recalled any specific defensive type wounds.
Is that something you generally would look for in an autopsy?
Yes, I'd look that in every case.
And would you document that if they were there?
Yes.
And you did not see any?
I did not.
Okay. And you did your autopsy on August 11th, 2023?
Yes.
And you wrote your report on January 10th, 2024?
Yes.
you did not test fire the gun in this case, correct?
Correct.
And you were, you've never been to the Hildabrand apartment, fair to say?
Correct.
Fair to say you were not there on August 6, 2023 at 2:47 a.m.?
I was not.
You were not in the apartment?
I was not.
You were not in the building?
I was not.
And you did not see who pulled the trigger on the gunshot that killed Saria Hildabrand?
I did not.
Thank you.
TV Director.
What was our last fix about? What's that? Our last one that we just did was 265, but the ones we did was 377.
376 and 378. Dr. Gallagher, Ms. Brewster handed you a number of pages from a textbook from Spitz and Fisher, particularly 328. Did the photograph on page 328 strike something with you?
It's just, again, that's an intermediate photograph. It's a, you got the defect of the skin, and it's surrounded by this dense pattern of abrasions, stipple marks. So that is a wound that, again, is intermediate range because it's not contact and things are not all going into the tissue at that point, but it's a much closer range because that pattern of stippling is very dense and very closely surrounding that entrance wound. So it's just a closer range.
Okay. And the text actually says where the, how distant it was, correct?
Let's see.
The adjacent injury, the one on the left, is inflicted at a close range 2 to 3 inches?
Yes.
Okay.
Yes.
And the bullet wound on the right, what does that show?
This is so that has a bullet wound on the right, has a well-demarcated ring of soot around that margin, and they're scorched. So just a close wound. Again, muzzle flame can come out of the weapon 1 to 3 inches. Soot can get onto the skin and the area up to 6, maybe 7 inches, depending on the gun and ammunition. And then beyond that period, as it gets further away, 6 inches, 7, 8, then you'll just get expanding patterns of the stipple marks that get smaller, just little red spots around the skin as it gets further away, up to the point that that particular weapon is too far away and the gunpowder doesn't have the kinetic energy required to leave marks on the skin at that point. So that from that point it becomes no longer an intermediate range wound, but it becomes an indeterminate range wound.
Okay. And so just for demonstrative purposes, I've marked that photograph. It states Exhibit 378. Is that what you have learned with those 2 gunshots would be a contact wound and a close contact, something 2 to 3 inches away?
Those would be good examples of a wound that's close. If there's nothing in between, like shirt or something that would filter that out. The one on the right is a good indication of what one would look like if it's a contact wound. Typically, if it's over the abdomen or chest, those contact wounds will be nice and round, like this particular one is, and it doesn't have any tearing. If it's a wound over the skull, because the skull is so close to the skin, a contact wound, the gas leaving the gun will kind of tent up the skin as it peels it away from the skull, and then that can tear. We call that stellate laceration of the content, when it needs to be basically a wound that occurs over a pretty shallow bone. So that's how that happens. And then again, the one on the left here shows one that is a very dense pattern of stippling, indicating a much closer wound.
And of course, it's always going to vary depending on the type of weapon and ammunition used, as you've already testified. At this point, Judge, I'd move to introduce what I've called, I said 378, but I'm actually going to call it 338 as a demonstrative exhibit. It won't go back to the jury, but I'd like to pass it around now so they can view that photograph to see the difference.
Assuming no objection.
Questions and approaching with 339. forgive the stripes from the color printer, but you were asked some questions about lividity and decomposition.
Yes.
Okay, and can you see Saria's coloring on that photograph?
Yes. So, yeah.
Okay, and you were asked some questions about whether that green-gray decomposition change on her neck can tell you anything about the time of death?
Yeah, she does have some that greenish kind of coloration, kind of green-gray coloration as the decomposition begins to progress. It's in her upper chest, neck. You can kind of see it around the bridge of the nose. And then she has other things on her skin that are just some slipping of the skin, which is another common thing. Post-mortem decomposition change begins to develop. So.
Okay. And I think you were asked about a 48 to 36 hour window. Does that show she's been decomposing for kind of at least that long?
Yeah, it depends. Certainly, she's got some level of decomposition going on, so it's not super immediate after the injury. And again, that's depending on the environment. Some people, if it's 106 degrees in Mississippi, you can get advancing decomposition quite quickly. In a cooler environment, that can be delayed somewhat. But I don't have anything more to say about this level of decomposition, other than she does have some developing, and you can see that in the skin.
Okay. And being in water for a period of time, how would that impact decomposition?
Yeah, it depends. Sometimes it can increase the rate. Sometimes it can decrease the rate. A cool water environment can slow the rate, and typically that rigidity of musculature, which is called the rigor mortis, that'll begin to develop in the first 12 hours and stay solid for 12 hours and then dissipate over the next 12 hours. But again, it's an environmental thing. It'll set up faster and go away quicker in the summertime in the south, and I've seen it last months up here in Alaska, just because someone in water during cold months and then recovered months later, and they still have some rigor. So it's certainly very temperature and environmentally dependent.
Okay. And in this case, in your report, you noted that rigor mortis was no longer present in Saria's extremities?
Yes.
Okay. You were asked about essentially a typographical mistake in your report, correct?
Yes.
Okay. On page 3, did you write indeterminate instead of intermediate?
I did, right under the head and neck in the sentence that's about to describe the entrance wound. I called that indeterminate. That is an error. It should have been intermediate.
Okay. But your opinion, the very first page, says intermediate.
Yes.
Okay. And you testified at the grand jury and said intermediate?
Yes.
And you met with Miss Brewster some time ago and clarified for her that that was a typo in your report?
I believe so.
Okay. May I show you a page of that transcript? Just go ahead and read that highlighted part and tell me if it refreshes your recollection.
Out loud or to myself?
To yourself.
Yes, I agree.
Okay. So you'd already clarified with her that that was a typo?
I did.
Okay. You're never saying that this is indeterminate. It's always been intermediate from your medical opinion?
Yes.
Okay. And I want to get back to the cause and, well, to the manner of death. You said the exam findings primarily guide your decision on manner of death, right?
Yes.
And to be able to put it in your report and on Ms. Hildabrand's death certificate, What degree of medical certainty do you have to have?
It's, I mean, certainly the death certificate is an opinion section. I mean, I do say on my first page of the report that it's opinion about the cause and manner. But my degree of medical certainty is a high level of medical certainty.
Okay. And your exam findings are that this is an intermediate gunshot range, which means was it likely to be self-inflicted?
Unlikely.
Why?
The distance of that patterned, relatively low density stippling, in my belief, is further away than someone could have triggered the weapon themselves, and it's not. It's unlikely to have been a pattern that can be inflicted by triggering it yourself. You'd have to have the distance from the gun to the head. So.
And does the angle and the side of the head matter if you know, like, that she was predominantly right-handed?
Not necessarily, because sometimes left-handed people can do it left side, right side. So that it's an unusual location. If you're considering a suicide, it's not a typical location for that.
Okay. Why?
Most suicides are either left temple, right temple, in the mouth, or underneath the skin, and they're almost all contact.
And this was decidedly not a contact wound?
Yes, no, it was not.
Okay, that's all the questions I have.
All right, thank you, Doctor. Let's speed stuff down. We've been going for quite a while. We're going to take a break.
All right, what do you guys want to what do you guys want to watch now? Lordy. Here, I thought I was getting over this cold. Sorry, guys. Whew. All right, what do we watch next? I feel like yesterday we watched everything yesterday. Well, we're not going to switch. We're not going to switch streams. We're going to stay on this stream. Want to watch closings? Oh, yeah. Let's watch closings again. That's a good one. Thank you for that, Iowa. That's a good one. Because closings did upload them. So let me see. They did upload those. See if I can find those. Oh, what? Maybe they. Let's see. Did they upload anything else? All right. There's closings. All right. Yeah, good one. All right. Here's state's closing. We did not see these from this angle. That's a good suggestion. Thank you for that. Let's see here.
Where?
All right. Get this sorted out. Let's see. Yeah, all right. So we did not see closings from this. Hey, Misty Janice, how are you? Oh my God. That's in my chest. The inside of the jury room, I know. Okay. I made you sneeze. And here I thought I was doing better. All right. These are closings from yesterday. We did not see these from this angle.
What happened to her? And when will we find her? At the beginning of this trial, Ms. Hurley told you that those were the questions that everybody except for the defendant was asking. And now you know exactly why he wasn't asking those questions. Because he murdered Saria Hildabrand with a single gunshot to the head at an intermediate range, likely 6 to 12 inches away, after a night of drinking, and she had caught him cheating on her. He shot her in the head and then callously disposed of her body down a storm drain. He perpetuated a lie about her being missing, and he has lied to every single person that he talked to about Saria's death. And he lied to you yesterday. But the defendant could not work his magic on the police, and he will not work his magic on you either. Because he knew what he was doing that night, and he remembers what happened. Selective amnesia is a coward's way out of a hard truth. He acted impulsively and drunkenly, no doubt, but he did act intentionally. And for that, he is guilty of murder in the first degree. I'm going to begin by discussing the law. Then we'll talk about the evidence that supports the elements of every crime charged. And finally, we'll conclude by discussing some of the defenses and why the defendant's story is absolutely unreasonable in light of what you know about the way the world works and in light of the evidence presented. So let's start with count one, and you can refer back to your jury instructions as we're doing this, but the state has charged murder in the first degree, and this is intentional murder. That's defined in instruction 20. The defendant intended to cause the death of another person, and he caused the death of another person. Those are the elements that the state has to prove. Murder in the first degree requires intentional conduct, and that's what separates murder in the first degree from the lesser included murder in the second degree, manslaughter, and criminally negligent homicide. Instruction 29 defines intentionally. A person acts intentionally with respect to a result described by a provision of law defining an offense when the person's conscious objective is to cause that result. When intentionally causing a particular result is an element of an offense, that intent need not be the person's only objective. So he can mean to do other things as well, as long as he means the act that killed her. An important thing about this definition, as you notice, is there is no premeditation requirement, and intent can be impulsive. Just like we talked about in jury selection, you can decide to do something in an instant as long as it is your conscious objective when you're doing it. We're also going to talk a little bit about voluntary intoxication. If you look at that instruction 29, you'll see that voluntary intoxication can be a defense to or is not a defense to a knowing, a reckless, or a criminally negligent crime. It's specifically listed in the definitions of knowingly, recklessly, and with criminal negligence, that it's absolutely just not a defense to those crimes. And so it's going to be a factual determination for the jury as far as murder in the first degree and intentional conduct. Like, was he so drunk that he could not form the intent to kill? And that's where you're going to look at all the surrounding evidence and decide that you don't cover up an accident. You cover up a crime. He knew what he was doing and he meant to do what he was doing. So that's the definition of murder in the first degree and intentional conduct. I want to talk to you a little bit about the lesser included. Instruction number 25 tells you how to work through those. You can deliberate on them in any order that you wish. The lesser included offenses of murder in the second degree, manslaughter, and criminally negligent homicide, they go in that order, but you never vote on the lesser ones unless you've unanimously decided he's not guilty on the higher. So you all have to agree he's not guilty of murder in the first degree before you go to the lesser included of murder in the second degree. Deliberate on them however you want, but don't fill out that verdict form and vote until you've decided that he's not guilty of murder in the first degree. The evidence shows that he's guilty of murder in the first degree, but just as you're thinking about it procedurally, that's how you do it. So let's talk about those lesser includeds for just a minute. Murder in the second degree, there's two theories. One, the defendant intended to cause serious physical injury and cause death. That's another intentional crime. Or the defendant knew that the conduct was substantially certain to cause death or serious physical injury and cause death. That's a knowing crime. You all don't have to agree to decide he's guilty of murder in the second degree. Which of those theories he committed? Half of you can think he intended to cause serious physical injury and killed her, and half of you can think he knew his conduct was substantially certain to cause death or serious physical injury and he killed her, as long as you all agree that he committed murder in the second degree. But you don't get here unless you're unanimous, not guilty on murder in the first degree. Then there's two other lessers below that. So if you all decide he's not guilty murder in the first degree, not guilty murder in the second degree, then you go to manslaughter, which is recklessly causing the death of another person, and then you go to criminally negligent homicide, which is causing the death of another person with criminal negligence. Again, the state submits that this is murder in the first degree. That's just how you work through those lesser includeds. So I want to talk about murder in the second degree. This is a charged offense for count 2. So all those first instructions go to count 1, murder in the first degree. The next charged offense is what we call an extreme indifference murder, or murder in the second degree. It's yet again a different theory of murder in the second degree, and that's satisfied if the defendant's conduct caused the death of another person, the defendant knowingly engaged in this conduct, and the conduct was performed under circumstances manifesting an extreme indifference to the value of human life. An extreme indifference means extreme recklessness. Again, instruction 29 defines knowingly and recklessly for you, and voluntary intoxication is not a defense to either of those mental states. So you have to ask yourself, well, what does extreme indifference mean? And the law gives you some instruction on this. It's in instruction 27. You should consider the social utility of the defendant's conduct. Getting trashed, getting a gun out, cheating on his wife and getting into a confrontation about that. There's no social utility to any of the conduct that occurred that night. The magnitude of the risk the defendant's conduct created, including both the nature of the harm that was foreseeable, would people think that this is a result that could occur from this, and by the defendant, and the likelihood that the defendant's conduct would cause that harm. If you point a loaded gun at somebody and pull the trigger, what's going to happen? And then the defendant's knowledge of that risk and any precautions he took to minimize the risk. Those are some of the factors when you decide extreme indifference. And then you have counts 3 and 4, which are the tampering with evidence counts. Count 3 is for the tampering with the evidence of the apartment, essentially the cleanup at the house that he did. And count 4 is for dumping her body into that storm drain. So we have to prove that the defendant knowingly destroyed, mutilated, altered, suppressed, concealed, or removed evidence, and that he did so with the intent to impair the physical evidence verity or availability in an official proceeding. This proceeding right here. So that's the law. I want to talk about the evidence. And going through the timeline is probably the best way to do that, because you have to decide, was he acting intentionally? Did he know what he was doing? And the acts leading up to what he did and the acts after are really, really critical to that. So let's start with Saturday, August 5th. And they're also critical to understanding the defenses. So what we know on August 5th is Saria and Zarrius went out to celebrate his 21st birthday. She was excited to go out. She picked out a new outfit. She decorated for him. She was going to have a good night for him. She was also the most sober in the group. If you recall the medical examiner's testimony, she's not even right around like half the legal limit at the time of her death, 0.046. And they start out at Dave & Buster's. They win this Pickle Rick that she was excited about, and then they move to Willowa, where they are drinking and dancing and having fun. Saria is doing the most of the dancing and having fun, but everybody is getting along. And at some point in the night, no doubt the defendant becomes intoxicated. It is his 21st birthday. The state is not saying that he's not drunk. He's just not drunk enough to not know what he's doing. And so they walk from Willowa to the gas light. He gets turned away at the gas light. and 4 of them, Marie, Isaac, Saria, and the defendant, take an Uber or a Lyft back to the house. The defendant is falling asleep, but also waking up in the Uber and telling people thanks for the good night. If you recall Marie's testimony, he was kind of in and out, but aware of who was with him and where they were going. And if you listen to his testimony, he was the one that wanted to go home. Like, he knows that he's hit a limit and needs to go home. And Saria helps him into the house, but he's able to walk on his own accord. Despite getting sick, he's up and he's moving. And then we move into the early morning hours of August 6th. We know that this is the last picture of the two taken together, and the time on the phone is just after midnight, 7 minutes after midnight. And then we know that this is what he looked like in the bar. He's intoxicated, he throws up in the Uber and outside the apartment, but he gets into the apartment. We know that at 1:18, the defendant and Saria make it home because Saria texts Zach Farrar. Farrar asks who's taking Marie home. Saria says she's driving. We know Marie makes it home at 1:34 from these text messages. And then we get to the critical part of the night. It is just the defendant and Saria at their home. And we know what happened because of the phone evidence. We know that she starts going through his phone at approximately 2:12 in the morning. And we know that because the photos that are on her phone are screenshots of his phone. And those screenshots tell the story of the timeline, right? They're taken at 2:12 and at 2:14. That's the number visible on his phone when she takes them. And first she goes through his Instagram. And the Instagram is clearly with a girl. He is clearly asking for photos. Show me what you got. He sends a photo. Do you have any more pics? He asks for a photo and she sends one. We know this is a girl that does not have Snapchat. She lives with her parents. Her parents control her social media apparently, so she's not living out on her own or being a full adult in the world. But he's carrying on a suspicious relationship on Instagram with this girl. Saria finds this and is undoubtedly upset because she sends it to herself. She also then goes through his Snapchat and finds these conversations with Cheyenne. And she's doing this about 10 minutes later between 2:21 and 2:22. And then all the way up to 2:24, all of these photographs are found and screenshotted on the defendant's phone and then sent to Saria's phone. And we know from the defendant that Cheyenne was somebody he had previously been involved with, that she had found out about and was upset about and had moved on from. And they're sending partially nude pictures back and forth, and that she's taking all of these screenshots all the way up until 2:24 a.m. The defendant is offering to fly Cheyenne up in the summer. And these are older photos, but of course they make her upset. She sends them to herself. And we know that they get on her phone between 2:18 and 2:24 a.m. And we know that from the records. Like, that's when she's looked at them and sent them to herself. And we also know that the defendant deletes them at 11:30 a.m. the next day. And he tells you he did that because he was embarrassed of them. But ladies and gentlemen, this is the motive. This is the thing that happened just moments before the fatal gunshot. We know 2:40 a.m. Saria calls Marie, either to talk about what was happening or what was going on with their fight, but Marie does not pick up. And just 8 minutes later, at 2:48 a.m., we hear from Taylor Engstrom on the 911 call. Here's my sound not on. think I lost my sound through the HDMI, but you recall this 911 phone call, and it was this. Taylor reports a gunshot. He says it's incredibly loud. He said it sounds like it's right outside of his window. He said it sounded like a 9mm, and it sounded very, very close. He was afraid and didn't want to look out his window. And what that tells you when you evaluate the defendant's testimony, that he slept through some gunshot and just woke up later next to Saria's dead body, it's not reasonable. Like, the neighbor 80 feet away knew that it was a gunshot and heard it. So the next morning, when the defendant gets up, you have to really look in the records. Well, you have to use your common sense, but if you look in the records, it's easy to disprove the defendant's story. He calls himself at 8:25 a.m. and likely trying to devise a story about what had happened to her. If she's calling him, she's not with him, right? So he's setting up a trail about what could have happened. And then he searches the Alaska Bush Company homepage, and he actually goes into and visits their homepage at 8:32 a.m. And his description for this, he at first just didn't know, and somewhere on direct examination, he said he, was looking at pornography later because that's where he found comfort. We can't get into his mind. There's a couple of different possible explanations for this. He's trying to plant a story, maybe looking to see what time their closing hours, so he can say Saria went there after, and he wasn't responsible for this, and somebody else killed her at the Bush Company, who knows? Or he's excited and aroused by what he did, and he's going to the Bush Company to look at things, just the same as he Googled the Castle Mega Store. You don't have to know which of those things he meant to know that he's not just finding comfort in the Bush Company webpage as his wife lies dead in the bed next to him. This is at 8:32 a.m. And then at 9:19 a.m., he maps to the Castle Megastore. Again, he's either thinking of a story or getting excited about what he's done. At 10:44 a.m., he texts Saria's boss, pretending to be Saria. And this is where he starts his lies, and they never stop. And they don't stop all the way through his testimony yesterday. Hey, this is Saria. I can't make it into work today. I went to Jimmy's last night and I'm pretty sure I got food poisoning from it. I'm so sorry. I would have called Craig, but I don't have his number. But Nadia Jones right away is suspicious of this because she does have Craig's number. She's called into Craig before. And so Nadia already, at the very first time the police talk to her, is suspicious of the defendant's story because she knows that Saria doesn't call in that often, and when she does, she has Craig's number. And we know that from her cell phone that Saria did have Craig's number saved. She just had it saved under the CEO of Bread and Brew and not his name, and that's why the defendant couldn't find it. So this is at 10 in the morning, 10:44 in the morning. The next thing he knows the next thing he does that we know about is he goes to Fred Meyer's for the first time, and he purchases Gatorade, marinara sauce, and Everyday Living Sheets. Gatorade, because he's working off a hangover. Everyday Living Sheets, because he's got to clean up the bedding, and it's a mess. And marinara sauce, again, we don't know why he's purchasing this. Is he purchasing this to make the rest of the transaction look normal? Is he purchasing this because he wants to eat something? There's no noodles or mozzarella sticks with it. Or is he purchasing this because he's 21 years old and the blood that he can't clean up he wants to disguise with spaghetti sauce? If there's things on the floor that he can't quite get up, if you run some spaghetti sauce over them, has he created a story for the stains on the carpet? But those are the main purchase here is the Everyday Living Sheets that we know end up on the bed. He then does some mapping and some traveling. Ronnie's barber shop, he told you apparently he was just thinking about how he needed a haircut. He went to Waldron Pond and he went to Bancroft Park. And this is where he is scoping out already, early in the morning after he's killed her, where to hide the body. And that's how you know that this is intentional. When normal people wake up and to the situation that the defendant says he found himself in, they don't assume that people are going to think they did it unless they did it. That's not a normal assumption. Normal people are going to say, oh my God, what happened? Let me try and save her. Let me call 911. He didn't. He's taking all of these steps to clean up. And at 2 o'clock in the afternoon, he is already looking for and finding the place that he's going to dump her body. And then he needs a break in the middle of the day from all of this cleaning. And he goes to the Brown Jug warehouse. He purchases the bottle of Four Roses and a 2-liter bottle of the Coke. And you can go back and watch that video. And you should watch this video in particular where he's standing in the cashier line at Brown Jug, just so completely unbothered by what he's done and what he's in the middle of doing. Much like his testimony, it's just so callous and so calculated and so unemotional and frankly selfish. Like this is what he's thinking of in this moment. And then he texts his dad, and his text messages with his dad are also really telling as to his mindset on that day. He's not scared. If he is, he's scared of what he did and that he's going to get caught. He's not sad that Saria's dead. He never once expresses through his whole testimony or through any of his actions grief. Not a moment of it. And that's evident when he texts his dad. His dad says, I hope you had fun last night. And he responds, I did. Maybe a little too much fun. And Dad's like, well, that's okay as long as no one got hurt or went to jail. And he texts his dad, well, neither of those things happened. And then he initiates on his own. I ended up getting that small batch of Four Roses. And his dad says, sweet, that's a good one. And you met the defendant's mother yesterday. Man, and you have to feel for her, right? Like, she didn't ask to be in this position. She didn't want to testify. And he didn't want her to come and hear these awful things. But by all accounts, he was adopted into a loving and caring family, people that were supportive of him, people that if he awoke to an accident or a suicide, he could have called for help. His dad is texting him on his birthday or on the day after to make sure he had a good night. But the defendant, selfish and narcissistic,
Objection.
Overruled.
sends his dad this picture. He's put ice in the cup. Saria's body is at this point still on the bed. Maybe he's moved her to the bathtub. It's really, at some point that likely happened from the scene evidence. He didn't disclose that. But her body is in the house because he hasn't bought that trash can yet. And he pours himself a drink. Not to numb the pain, but because he's thinking of nobody other than himself. At 6:12 p.m., he takes the second trip to Fred Meyer, and he buys what he tells you is hydrogen peroxide in an empty spray bottle to clean up the blood, and Old Spice deodorant and cotton swabs just for his personal hygiene. Unbothered again why he does this. He uses his loyalty card so he gets the discount. He goes back to the house, and then at 8:10 p.m. he realizes he has to actually move this body. And he goes to Lowe's and he purchases a 96-gallon trash can. That transaction happens at 8:10 p.m. or 20:10:58 on the register here. And you can see him walking up, checking out, and leaving Lowe's. 10 o'clock, he makes his third trip to Fred Meyer's. He's getting Red Bull, the yellow edition that was seen in his car when the police took photos of it, because he's tired now. He's been up all day after drinking and murdering his wife all night. And he gets a queen-size mattress pad because he realizes the sheets aren't going to do it. And he's got to sleep somewhere, right? He's not going to lay on the bed that's soaked in blood. So he gets a queen-size mattress pad as well. Into the evening of Monday, August 7th, so this is the night after he's done all of the cleanup, you can look at his travels, and this is in the cell phone evidence that was introduced, but between 11 p.m. on 8/6 and 5 a.m. on 8/7, he travels over 2,200 meters. You can see the distance traveled. Remember, Detective Paternose's testimony that in her training and experience, this is reported out as meters. The biggest group here is from 11 p.m. to midnight, but he is moving all night long, all the way up, and it's reverse chronological order, right? So it starts at 11 p.m. here on the 6th, all the way till 5 in the morning. He is moving all night long, the night of the 6th, morning of the 7th. When you do the math, if there's 3 feet in a meter roughly, he travels about a 1.36 miles, which makes sense when we know where the body's located. The apartment's right here, the storm drain's right here, that's dragging it all the way there. He loaded her into the trash can. He described really, really callously how he did that, how he had to drag her. And if you'll recall, when I asked him, was that difficult? He doesn't say it was emotionally difficult. He says it wasn't easy. No, it wasn't. That's not a light task. And the storm drain isn't a low storm drain. He put in some physical labor that night to move her to the storm drain. Lazy physical labor. He took her within sight of his house, but he put in the steps that are documented by his phone. And then on August 7th, he reports to work like regular. If you look at his searching, he's searching the Mount Baldy trailhead, he's searching for online outdoor clothing, Patagonia, and some other brands. He also views TikTok, and one of the things you'll see he does is he views TikTok and Instagram, and then there's this thing called Linktree, which Detective Paternose didn't know, but said, oh yeah, you can link to people's other social media handles from their page. And he's going to several OnlyFans accounts from there. So what he's doing is he's going to girls' Instagram pages, clicking on their Linktree on their OnlyFans account, and then going to do that. Not because he finds comfort in porn, but because that's just what he does. And he is, again, unbothered by what he's done, except for that he doesn't want to get caught. But he knows that people are going to start asking questions, right? In fact, all day long, yesterday, on Sunday, Marie had been asking questions, seeing if they wanted to go out to brunch, etc., and he gave her the thumbs up. Well, her best friend isn't going to go away. He has to tell her that she didn't come home or tell her the story. And that's the first time he's had now 30 hours to think of this lie that she walked to work and didn't come home, and he tells Marie that she didn't come home sometime in the midday. And then Marie catches up with him after work. And that's when we see the first time he's, faking like he's looking for her. At 5:02, he just generically searches hospitals on his phone. And then at 5:34, Marie makes the 911 call. And I don't think my audio is going to work here, but you can recall the phone call where Marie says, I think my friend is missing. And the dispatcher says, and she's relaying the details as she knows them. And the dispatcher even says, why isn't her husband calling? and she puts it on speakerphone so that Zarrius can answer the questions. And he tells that story that he began with Marie and never stops after that. That she left for work at 10, she's wearing all black, she had her purse and her wallet with her, she forgot her phone. Critical hole in that story that the detectives pick up on immediately is that text message to Nadia comes in at 10:44. But that's the story he's told, and that's the story he's stuck with. Officer Zhang is dispatched, and the defendant lies to him. He tells the exact same lie. She left at 10 a.m., she left her phone, she took her stuff, she's wearing all black. Here's the route she would have walked to Bread and Brew. And he's keeping the police away from Bancroft Park. He's sending them to the side instead of straight up that access road. And then at 7:44, Meredith Barney gets the call that no mother should ever get, that her daughter's missing. And she does what somebody who loves somebody that has suffered an accident does. She gets on the plane immediately, without hesitation, and she's in Anchorage the next day. Overnight, her sister comes and she comes. That is how people who love and cares for somebody that is missing or an accident has happened behave. They don't think, oh my God, somebody's going to think I did it. That's not something somebody thinks unless, oh my God, they did it. So Meredith Barney, immediately after that phone call, makes plans when she gets here. And she gets here the next day, Tuesday, August 8th. Her and her sister land and meet with the police, and Detective Clark and Detective Elby meet the defendant at his home. And it is not a phenomenal audio with the air conditioning and the dogs barking, but it gives a real sense of how the defendant talked to and interacted with police. He is casual. He's providing information. He is given every opportunity to say the truth. And he doesn't. He perpetuates this lie that she's missing. But he can feel the walls starting to close because at the end of, because Detective Elby took him back to the bedroom, first of all, and said, can I look under the bed? And he's concerned about potential sex toys that might be under there. We know now that he's concerned about the blood on the bottom of the mattress. But also that the detectives are asking hard questions. They're saying, this timeline doesn't make sense. How is she texting into work if you have her phone? And so he knows his story's falling apart. And that day, a 70 to 80 person search is conducted of the area. So we know he's perpetuated his line to her command, to his command, to Captain Phelan, his friend Dalen Gates. They've all heard this lie now. And the military man, they come out in full force. And they walk the park, and the police walk the park, and Meredith and her sister walk the park with the defendant. That day, the detectives are collecting and reviewing traffic cameras, they're contacting witnesses, they're canvassing the area, trying to find Saria. And what's the defendant doing while all of this is happening? He's looking at many vids, which is, again, pornography. That's how he's spending his time while people are out looking for his wife. On August 8th, he also texts or Googles shortcuts for texting on an iPhone because he knows the detectives have figured out that she couldn't have texted into work if he had her phone at 10:44. So he's trying to figure out a story for that, which he tells Detective Elby and Detective Lee the next day. But here's where he's figuring that out. He also knows the detectives are closing in on him, and he's getting worried, selfishly concerned about himself and his own salvation. And he Googles for a prayer. It says pray, but prayer to say to accept God. On Wednesday, August 9th, the defendant meets with Detective Elby at the Detective LB and Detective Lee at the Mockingbird residence outside, and he wants information about that search. You can hear he wants to talk to the dog, the woman that's running the canine track, and you heard that part on the audio where he's like, "What are you going to do? What are you going to find?" And he said, and the woman who's running the dog track says, "You know, the rain, we're probably not getting anything. The dog couldn't get a scent." And maybe he has a sigh of relief there for a moment. But he also that day wants to get inside the house. And at this point, the house is been seized and he's not allowed back in it. And he gives the police the story about Saria. She must have set up a shortcut on her phone to send that automated text message because she knew she was going to call out. The search warrant is executed at the defendant's home, and they find some really, really critical evidence, 2 firearms. And there's this pseudo-suicide note, and you can read it for yourself. He is, again, thinking only of himself in that he's not saying what really happened to Saria. He's still pretending that she's missing. And he tells his mom it's not a suicide note. He tells you all it was. You can read it and make your own decision, but that's found. And there's extensive evidence of cleanup. The mattress is flipped over. There's new sheets in the mattress topper. There's presumptive blood on the floor. And you saw that blue star evidence that is really, really strong evidence of cleanup on the carpet and on the bathroom. And the defendant knows, like he calls Detective Clark and says, "How long is the search warrant going to be? Are they going to be looking in bags or anything? Like, what are they going to be looking for?" He is searching for information. Again, he feels the walls of this investigation closing in on him. Was anything found by the dogs? Will they be looking in bags and compartments? And he won't provide any new information to Detective Clark to help find his wife. He insists, "I already told Detective LB and Detective Lee everything that I know." And he rushes off the phone. "I've got to go. Somebody's calling me. I don't know who it is, but I got to call him back." And this is what is found in the apartment. And this is where you really get into the defendant's story, that the lie that he told you yesterday. It makes absolutely no sense that this was anything other than a murder and an immediate attempt to clean up, because there are 3 distinct pools of blood, right? She has 1 bullet hole. Like, she is shot once in the head, which means she's moved while there's still a fair amount of blood in her to leak out, at least twice while on this bed. You can see those, and you remember Detective Chelsea C. talking about this grip pattern. There's movement from there to there, while there's still sufficient blood to be leaking in that quantity and saturating through the mattress. You can see all those patterns really succinctly here. And the defendant says, "Well, it looked different because these slats weren't there before." Yeah, because you flipped it over and it saturated into the wooden slats, is exactly what happened there. The detectives also find the carpet shampooer that tests presumptively positive for blood, and you heard from DNA analyst Emily Matthews that this, both the stains on the mattress and the swabs from the carpet cleaner matched Saria's blood. There's the mop. Detective Clark is looking at the photos as they come out of the crime scene team, and he says, "Hey, that seems unusual. This isn't a particularly clean home. Why is there a standing mop bucket there?" And I think that mop bucket might be at Lowe's. And he Googles it and finds that mop bucket for sale at Lowe's. And Detective Lee's already at Lowe's picking up the trash can information. And he goes and finds that mop bucket sure is sold there. And then, if we can turn down the lights, Madam Clerk, I do want to talk about this blue star evidence. You've got the hallway between the bedroom and the bathroom, and evidence of blood or cleanup there on the floor. And then you've got the bathtub, and you've seen this home, right? Like, it is not pristine. The second bedroom, frankly, they've let the dogs completely destroy. The kitchen is full of dishes in the sink. The counters have not been cleaned, but this bathtub is pristine. And there is all this evidence of presumptive blood or cleanup on the bathtub and the floor directly in front of the bathtub and in the sink. And so this is where the defendant's story, we can turn that back up, please, Madam Clerk. This is where the defendant's story about what he did that day when he was cleaning her up kind of breaks down. Like, she was moved. There was blood in that bathroom, undoubtedly, or substantial cleanup, and you have to ask yourself why. The other thing the detectives find at the residence is this weapon. And this ends up being, after ballistics testing, the murder weapon. And there's a lot of question about DNA analysis and like why we didn't find DNA on this. And a couple of things to remember about this gun is clearly the defendant possesses it, has it in his hand after the murder. His DNA is going to be on it regardless if they're even able to get it. They're not able to get DNA off that gun. But also we know Dalen Gates said he handled that weapon after. And that's interesting too, right? Like that the defendant his friend is offering to go out to search with him and they're gonna take weapons just in case. And the defendant says to Mr. Gates, why don't you take this one? And has his friend handle that weapon. Obscuring evidence if he's thinking that far ahead. Just something to think about. It's interesting that the murder weapon is the weapon that he would put in his friend's hand afterwards. That's State's Exhibit 26. And the police also find this suicide note here. It says, I'm writing this just in case what's going on with my wife becomes too much for me to handle. I've always said, since we met, that I couldn't live life without her. And I want whoever finds this note to please make sure my dogs are taken care of. I want that to be the main priority. To all of my family members and loved ones, I'm sorry I wasn't mentally strong enough to handle the weight of what's going on. What's going on is that he murdered his wife. Not that she's missing, not that she suffered an accident. I loved Saria, but I've prepared for the worst, unfortunately. Please make sure that if Saria is found, rather it be dead or alive, that we get buried next to each other, please. Finally, to Saria, if you are alive. It's like so weird. He's writing this note knowing that she's dead. That's some real cognitive.
All right, sorry, I just want to jump in here. Yeah, if their server is down, we're not going to see the verdict. It's kind of going back and forth. Their server's kind of up and down. So sometimes it's up, sometimes it's down. So they're having some issues with their server. So yeah, we will not see the verdict. We won't see it live. If there's a verdict right now, we won't be able to watch it. So after all, after all of our hard work and dedication, we would not be able to see it live. And there's that. Yeah, so right now it's kind of up. It's limping along. I don't know. Well, we'll just have to wait and see what happens at the time of. At the time of when it happens, we'll have to see if it's up for us or not. Because this is the only way that we can watch live is through their court system. Because the channel Newton works for, they upload it later. They upload it afterwards. Because remember, the jury is right there where he's filming. He can't film live. That's why they're not filming live. So I will let you guys know if and when a verdict comes in, if we're able to see it or not. So fingers crossed. Could be a bug, Aaron's saying. Yeah, could be a bug. It's always something. Well, we'll just, it is what it is. We'll just have to see what happens at the time of. We'll just have to see what happens at the time. All right, see, now it's back up. So whatever they're that'll really stink if they're down and we can't see it. I mean, on top of everything else with this trial, why not? we can't watch the verdict live. Ah! Jeez. All right. Well, let's cross that bridge when we get there. Let's just cross that bridge. Cross that bridge when we get there. Debbie, no, because we're following Kathy Russin, and also Newton is there, so we've got a couple sources that are there, so it's good. It's all good. All right, so we'll cross that bridge when we get there. Let's keep watching this, and then I'll check in a little bit.
Dissonance, right? Like separating yourself from the thing that you did. You've been telling this lies for days. You perpetuated it on the stand because that's how you deal with it, right? Like if you're dead or alive, we get buried next to each other. Finally, to Saria, if you are alive and receive this news, I'll see you in the next life, honey bunny. I love you the most. It's a pseudo-suicide note. He tells his mom it's not a suicide note. It's clearly he's contemplating, ending his life because of the weight of the guilt of what he did. Not the weight of finding her dead. He's never said he's grief-stricken about her ever. He was asked 15 times yesterday how he was feeling. He never said sad. He never said grief-stricken. He never said mournful. His mom was asked, in all the times you've talked to him since this, has he ever said he missed Saria? No. He is contemplating killing himself because of the weight, the guilt of what he did. He doesn't want to go to jail. He doesn't want to get caught. He has committed murder. He also doesn't want to be on suicide protocol in jail because that's hard. They isolate you. And that's why he tells the folks at jail and his mom that this isn't a suicide note. You all can make your own conclusions about it. The state suggests it's indicative of some real cognitive dissonance. Somebody trying to make peace with what they've done because it's too awful to think about. He also writes a note to the people working the case that he's really sorry that the info he gave wasn't the best, and hopefully my wife turns up. But I'm telling you now that I have no clue what could have happened to Saria, and I truthfully can make that statement. When I asked him yesterday, and this is where truly, your deliberations stop. I'm like, you don't know that you didn't pull the trigger, do you? And he said, no, he doesn't know. So all this opening statement and questions about whether it was suicide or an accident, that's not real. There's no evidence that this was suicide. There's no evidence that this was an accident. And he knows it. And he knew it when he took the stand. And so then we get to Thursday, August 10th. The detectives know that her body's got to be close. There's the blood under the mattress. They don't have it yet, though, and they can't. It's really hard to charge murder when you don't know for certain that the person's dead. You need a body. So he is being watched by the people on base. Somebody's checking in with him every 2 hours, and the cops are working hard. We've got to find her. We know that he's purchased the trash can at Lowe's, and lo and behold, A1 Landscaping finds that trash can. Man just steps away from the storm drain. And that trash can is processed by a really, really experienced and good crime scene team, and they find 2 pieces of organic material that they send to the crime lab. Everybody calls it organic material. I don't know why we're fighting about that term. It looks like sloughed skin, but there's not a test for that. But it's organic material. It's not paper. It's not Clorox wipes. And what it does have on it is Saria's blood. 2 pieces of organic material and what appears to be blood in the bottom of that. And then shortly after they're finished processing this on the 10th, Detective Chakowski is out. They've flown the drones all day. They're looking for her. They can't find her, and he is standing just yards away from that storm drain, and he says to Officer Miller, "Have your flashlight." presuming somebody might have looked in there before, and they find Saria's body dumped in the most callous way possible. She is thrown 15 feet down. He didn't place her in that storm drain. He did nothing lovingly about this. He took her in a trash can and levered her over the top of that storm drain and dumped her 15 feet down to cover what he did. And the detectives find that, and they find it. It's callous and lazy. So close to the apartment. So close to the apartment. And now he's done. And the detectives take him into custody, and they take his DNA, and they take his fingerprints. And he's charged with murder. And you all are going to evaluate the evidence, and you're going to decide that he committed intentional murder. The evidence you have to evaluate, I'll divide into kind of a couple of categories. The first you have is testimonial evidence. You have Saria and the defendant's friends, her coworkers, and her mom. And what we know from all of this testimonial evidence is that she was a positive person. She was happy when she went out that night. They weren't having more than normal marital trouble, meaning she found text messages to a girl before and gotten over it, and there hadn't been anything that summer. We know from his mom that she was there, just a month before this happened, and they seemed to be getting along, and she loved Saria. Saria was a happy, positive, good person. She was planning for her future. She was enrolled in school. She wanted to go into medicine. She was in the Army to be in the Army National Guard to become a combat medic. That's why she came up to Alaska, so they could pay for some of that schooling. She was planning for her future. She was not suicidal at all. There's no evidence of this. And in the group, she's the most sober. She didn't make some drunken, outrageous decision to take her own life. Or she's also weapons trained, right? She didn't handle that weapon and have it go off accidentally because she was mad. She's the most sober of this group, and she's got no reason to do that. What she does have a reason to do is confront her husband about being unfaithful essentially since they got married. Right? She's undoubtedly mad about that. She calls her friend, and she's going to talk to him about it. And he responded violently. But we know that the defendant was intoxicated from this testimonial evidence, but he's not completely out of it. He knows that he's the one that wants to go home. He's passing out and waking up and saying thanks for the good night in the Uber, and he walks on his own 2 feet with Saria's assistance into the house. He's aware of his surroundings. We have the crime scene evidence that we've talked about extensively. We have the weapons, the flipped mattress, the evidence of the cleanup, the suicide note. We have the recovered trash can, and we have the storm drain. All of those different scenes were processed by an exceptionally well-trained and professional team. And then the defendant's vehicle that has the gas can in the back of it, and the detectives are like, hey, that's weird because we smell gas. And sure enough, they did. The defendant admits that he poured gas on that bedding because he was going to burn it. And then you have the testimony of the state medical examiner. And here, between the state medical examiner and the ballistics expert, Samantha Castle, that's where the rubber meets the road on was this intentional or was this accidental as far as physical evidence goes. And he tells you, and his whole job is to determine cause and manner of death, and he has to do so to a high degree of medical certainty, and he has to sign a death certificate that says those things. Suicide and undetermined are options for him, and they're options that he uses. And he decided, in his medical expertise, after doing a full head-to-toe autopsy of Saria's body, that her cause of death was a single penetrating gunshot wound to the left forehead. And that positioning on the left forehead becomes really critical when we talk about intentionality. And the manner of death that he certifies is homicide. He signed with his MD after it that this was a homicide, and that means at the hands of somebody else. And he did so because it is an intermediate range gunshot wound. It is not a contact wound. And Detective Clark told you he has responded to hundreds of suicides and never seen a suicide that wasn't a contact wound. And a contact wound looks very different. It has a real distinct pattern of burning and soot right around the gunshot. And it's awful and terrible to look at and think about. But this isn't a contact wound, and it's not a near contact wound. It's an intermediate distance. She's got a pattern of stippling, which is those burnt gun particles outside of the left side of her head that goes out 9 centimeters. So he said suicide is improbable, and he certified the death as a homicide. And I want to look at that photograph again, just so you can look at it. There is no evidence of a contact wound there. Both he and the ballistics expert said that. It's not contact and it's not near contact, which means it is, according to the ballistics expert, probably about 6 inches out. And you're going to have that orange dummy gun back in the jury room. You can't put your hand in this position, release the safety, and pull that trigger like a gun pulls back, and this hurts. It is unnatural to do, especially with your dominant hand. And it's bad with your non-dominant hand too, to get that pattern that starts here and goes out here. Like, it's just not a way that people kill themselves. It's not a way that the detective has ever seen somebody kill themselves, and the medical examiner said it's not a contact wound. This isn't a suicide, and it wasn't done by Saria's own hand. And then we have the crime lab evidence. First, we have Aaron Clay. He looked at latent prints. The only usable prints we had were on that Glock case. This just shows that the state, they pulled out all the stops. They tried to find all of the evidence that they possibly could. And what we got was some prints off the Glock case that we couldn't, that were able to be matched to Mr. Hildabrand. We're going to talk a lot about his credibility, and we have talked about it a lot about his credibility, but man, when he wouldn't answer whose Glock that was weird. It was weird. It has nothing to do with the case. Like, that Glock wasn't used in this incident, but when you're deciding, like, is somebody being truthful to you? Like, he knows whose weapon that is. I'm not pushing it because, frankly, the state doesn't care because it's not part of the evidence in this case, but it's really weird that he wouldn't say it. And then you have Samantha Castle. She did ballistics, and she identified the murder weapon, that Sig Sauer, as the gun that fired the bullet fragments that were found in Saria's brain and her skull. And she did muzzle to target distance testing, and you can go back and compare, like, that autopsy photo and the Naga hide test that she did. And she says, I can say it's further away than contact, less than 12 inches, probably closest to 6 inches. And you can look at that, and that's borne out by that testing. And then you can think, is this reasonable? And it's not for a suicide. And then you have the expert testimony of Dr. Emily Matthews. And there's no blood on that Sig Sauer, no blood on that murder weapon. And so that tells you it might be further out than 6 inches, right? Because you would expect some blowback, but certainly not closer. And it's certainly not contact, because there's no blood on that gun that you would expect if it were a contact wound. But she also testified that there was blood and DNA matching Saria Hildabrand on the mattress, on the swabs from the carpet shampooer, and on the organic material from the trash can. All things that help put the story together about what the defendant did, both during the homicide and after. Both during the homicide and after. And that's what we want to talk about when we talk about intent and we talk about motive. You have a jury instruction. It's in your packet. It's instruction number 31. And it says that motive is not an element of the crime charged or any of the crimes charged. However, presence of motive may tend to establish guilt. An absence of motive may tend to establish innocence. You may therefore give its presence or absence the weight you believe it should have as evidence. Ladies and gentlemen, the state submits that those Snapchat records with Cheyenne, who Saria had known about before, but the Instagram messages with somebody else who appears to be younger are certainly evidence of motive. The defendant is messaging 2 different women asking to exchange nude photographs, and she caught him. She caught him and she was done. And that is why he killed her. We don't have to prove motive, but it helps. It helps you decide. In that moment, when he pulled the trigger, did he mean to do it? So, motive is an indicator of intentional conduct. She found out he had been cheating. She tried to call Marie. She confronted him, and 8 minutes later, she's dead. And we know from the medical examiner that gunshot wound would have killed her instantly. And that's how we know that he's moving her around on the bed while she's still bleeding, because she's not moving herself. That wound would have killed her instantly. I've talked a little bit about this, but we have to confront voluntary intoxication. And Instruction 29 lays out all of the mental states for you. Voluntary intoxication is not a defense to knowing, reckless, or criminally negligent crimes. So it's not a defense at all to murder 2, manslaughter, criminally negligent homicide. It's just not. It can be to murder 1 if you find that he was so drunk that he couldn't form the intent. It may be offered in court to negate an element of an offense that requires a defendant to have acted intentionally. So was he so intoxicated that he couldn't inform the intent to kill? Absolutely not. He was responsive to his friends in the Uber. He was oriented to time, place, and people. He had a motive to kill. Saria caught him cheating just moments before the deadly shot. And selective amnesia, I said it before, is a coward's way to deal with uncomfortable truths. The things that he chose to remember and not remember are concerning, right? He can't remember where he found the gun or if he cleaned it. But supposedly he's up and on the phone and knows she's dead in the morning. Like, what he's choosing to remember and not remember are about convenience and about difficulty, not about the truth. His actions afterward are evidence of his intent at the time. Nobody that wakes up to a shock of their partner dead says, oh my God, people are going to presume I did it. Unless, oh my God, you did it. Normal people would wake up and try and help. A reasonable person would wake up and call 911. A reasonable person would be sad and grief-stricken.
Overruled.
The defendant's story is not reasonable. His selective amnesia is just a means of cognitive dissonance. It's what he wants to tell himself because it makes him feel better about it. His actions afterwards, when he right away starts Googling the Bush Company and the Castle Mega Store and texting into work and buying cleaning supplies and having a drink and purchasing a garbage can and dumping her body down a storm drain are evidence that he killed her and he was covering it up. And being blackout drunk does not absolve him of liability. Like, it's his 21st birthday, absolutely. But being blackout drunk is not necessarily a defense. His testimony was that he routinely has done things while he's drunk that he doesn't remember. And it is his habit to get up in the morning and check his social medias and check his bank to see what happened. If it's Amazon Prime Day. If he made $1,000 worth of purchases last night while he's drunk, Amazon's not going to forgive them. In the moment, when he's really drunk, he can intend what he's doing and forget it. Like, just because his brain's not recording the memory because he's so drunk doesn't mean that when he was drunk he didn't intend to do it. He intended to kill her because she confronted him about cheating. He's still guilty if he meant to do it in the moment, even if you believe that he can't remember it. But there's no reason to believe he can't remember it. He can remember. He remembers specific details all the way up until it's convenient to forget. He remembers details after, unless it's inconvenient, like if he cleaned the gun. And his testimony was absolutely unconvincing. He was callous, he was unfeeling, he was selfish, and it was scripted. When asked about what happened in various times that wasn't a script for him, he couldn't tell. But when he's on script, he could tell you. And that's a thing that you can ascertain for yourself. But think about the way he talked about Saria. He didn't call her by name. He said, my wife, repeatedly about her. He didn't say, if he ever used her name, it was my wife, Saria. She wasn't her own independent being to him in that testimony. The other thing, when he talked about her body, he called it a lot. Like, he's cognitive dissonance to the max, right? Like, it was all about, what are you feeling? I'm feeling guilt. I'm feeling afraid. It was never about this life that he took and the life that she's not having because of him. It was incredibly selfish and narcissistic. And instruction number, I want to say it's number 10, talks about witness credibility, and it's worth looking at just because these are all things that I think jurors normally think about when you're evaluating if somebody is credible as a witness. And it tells you just a number of things that you should evaluate: their attitude, behavior, appearance on the stand, and the way they testify. You can consider his attitude, appearance, behavior on the stand, and the way he testified. You can consider, number 4, the accuracy of his memory. Any motive he has to not tell the truth. And the consistency of his testimony, number 10. And whether it is supported or contradicted by other evidence. And all of these things will lead you to believe that the defense is unreasonable and he's guilty of murder in the first degree.
Objection.
Overruled.
No one covers up a suicide. The defense is unreasonable. No one covers up an accident. They render aid and call the police. Guilty people cover up a crime. And the defendant told his mom that he would come in here and work his magic on you, do what he's done his whole life. And you heard her say, make them feel for you. And he said, yeah, what I've done my whole life. Ladies and gentlemen, do not let him work his magic. He knows exactly what he did. This was intentional.
Does Lars think he'd have a good chance if he go to trial? Okay.
That's if I can get on the fucking stand and tell a testimony, and if I can get on the stand, I don't want to say work my magic, but.
Yeah, I know what you mean. Make the jury, yeah. Feel for you. I know.
I can do what I've been doing my whole life, essentially, but I don't know if I can do that with this. So.
Yeah, I know. Sure.
Ladies and gentlemen, this wasn't suicide. It wasn't an accident. It was intentional murder. It was murder in the first degree. It was also extremely reckless murder as charged in count 2, murder in the second degree. You can vote on that separate and distinct from count 1. And he obviously tampered with evidence. The state submits that after you deliberate and look at all of the evidence in front of you, you will find him guilty of all 4 charges. Thank you.
Thank you. Counsel approach, please.
All right, we still do not have a verdict. So give me a second. I'm going to end the stream over here, and then we'll come over here. Just give me a moment. All right. All right. Welcome in, everybody. Welcome in for those that were watching the Blaze Taylor trial. Appreciate you guys coming over here, hanging out with us over here. We are still in verdict watch. Almost 7.5 hours. I'm going to, I just finished state's closing arguments, and I've got the defense closing arguments. So let's go check this out. And I really don't know what to say other than
Homicide.
I said at the beginning of this verdict watch, you never know what a jury's going to do, right? You just never know what a jury's going to do. And I thought I was being optimistic. I thought I went with 1 to 2 hours, only because I was basing that off of the previous trial we watched, Zachariah Rosh, pretty much the same situation. He was driving. His ex-wife was in the car. They had just had a really good day, actually a good weekend. And she grabbed the firearm and apparently took her own life. He drives to his parents, which is where he's living, and he proceeds to try to burn her, which he does somewhat burn Crystal's body. So then we get to this trial, and that was 2 hours and 9 minutes, I think. So then we get to this trial, and I kind of heard the circumstances, and I'm like, okay. And after watching this trial, I'm like, there was more evidence showing that Zarrius did this than there was showing Zachariah doing it. So that jury came back in 2 hours and 9 minutes. We're now at 7 hours 22 minutes for this trial. And again, it's not precise. I'm sure it's not exact because I started it about 5 minutes after the judge said, go back, the evidence will be coming in. So it may be off by a little bit, but it's not off by like an hour. It may be off by a few minutes here or there. So I was basing my prediction was 1 to 2 hours. I honestly thought it would be under 2 hours, only because there's more evidence, in my opinion, more evidence showing that Saria did not do this versus Crystal doing it. At least with Crystal, it was closer. I think there was. There was a little bit more evidence showing that she could have done it. In this case, I'm not seeing any evidence that Saria did this herself. And then on top of it, Zarrius admits he tampered with evidence. He admits in the apartment building, he got a 96-gallon gallon trash can. He bought cleaning supplies, carpet cleaner, hydrogen peroxide, etc. So did Rosh. He bought a bunch of cleaning supplies as well. But Zarrius admits in the apartment, he cleaned up the apartment. He on cross, he said how he put Saria's body from the bed. He moved her body from the bed into the trash can. He told us how he did that. He told us he wheeled her to the drain pipe. He said how he dumped her body into that drain pipe. I mean, he told us all of this stuff. I'm having having difficulty understanding because there was more evidence in this trial showing his guilt than there was in the Zachariah Rosh trial, and they came back in 2 hours and 9 minutes. So that's why I'm like, wow, 7 hours and 24 minutes. A little bit of a. I was surprised yesterday. Now I'm kind of getting into that. Like, wow, like what's going on? What's going on in that jury room? What is going on in that jury room? So, all right. What are you guys talking about? Hey, Anthony, how are you? Good to see you. Thank you for joining us. Appreciate you coming in. Honey Badger, there has been no activity, no playback, no questions, no activity whatsoever. No activity whatsoever. JMS agrees, yeah, it's like, just comparing it, that's just for comparison's sake, because we literally just covered almost the exact same kind of circumstances. Wife, spouse, significant other, somehow tragically, pulls the trigger, ends their life. The husband, spouse, significant other cleans up, disposes of said body in a very terrible way. One's being burned, one's being dumped into a drain, pipe drain. Both lie to police, both lie to friends, both lie to family. I mean, it's like the parallels are just amazing. Parallels between these two trials are quite honestly very, very, very similar. So that's why I thought there's no way they're going to take more than 3 hours. I don't know. So anyway, that's where we are. That is where we are. 11:25, almost lunchtime there. Grampy, are you with us? Newton Ward starting to get antsy. Yeah, man, I just don't. I'm. And then here's the other thing. Usually, like, at what point in time is the jury going to be, hey, judge, we need to talk. We're not able to come to an understanding. We've got a split. 10, whatever it is. They don't even have to say what the split is. They can just say, hey, we have a split. Judge doesn't want to know what the split is. They just want to know. I'm surprised that the jury hasn't said, or maybe they're still trying to hammer it out. And at what point does the judge do a temperature check? At what point does the judge do a temperature check and say, hey, jury, we just want to find out, where you guys stand. But would that be considered like, tampering, if you will? Would that be considered, putting your, I mean, at some point the judge is going to have to step in. And at some point the judge is going to have to be like, all right, jury, what the heck's going on? Where do you guys stand? Lunchtime there, yep. Lunchtime on the left coast. Saradera, I am perplexed as to what they are discussing. I really thought this was going to be an easy peasy. I forgot so too. All right, DC says, here is something that a lot of people don't get. Alaska is a non-reciprocal discovery state. The state must give the defense all of its materials, and the defense has to turn over almost nothing. Camilla, just a check-in would be okay, right? I don't know. I mean, I'm not sure how much that becomes the judge, like, nudging, right? The judge becomes a nudge. You don't want the judge to become a nudge. You don't want a nudgy judge. You want the judge to be, you guys do what you got to do, So it's a fine line, right? It's a fine line. Let's see. So DC says, but this means if a jury does hang, the state now knows more about the defendant's defense the second time around. Joe survived the portal. So good. Glad you survived the portal, Joe. Not even a question, Michelle. Not even a question from the jury. It is absolutely, I'm just going to say stunning at this point. It's almost 7.5 hours. 7.5 hours. What's the longest? Let me look back. I'm going to look. I'm sorry, guys. All right, I'm going to look back. I'm looking back at the trials we've covered just from last year. We covered trials before that, but just the trials that we covered. Let me see if I have them written down here. All right, Zachary Hughes. You remember Zachary Hughes out of South Carolina? That was a good one. 2 hours and 42 minutes. Monica Sementili was 9.5 hours. So Monica Sementili was 9.5 hours. And that lasted 39 days. That lasted 39 days, and that was 9.5 hours. This trial lasted 9 days, and we had We had 37 witnesses altogether. Monica Sementili had like 50, 60 witnesses. 9.5 hours. That's probably the one that went the longest. Oh, wow. Gerald Radford, remember that was the dog park one? That one lasted 8 hours and 45 minutes. So that was a long one. Oh, no, wait a minute. That was 11? Oh, it was 11 hours. Holy crap. Sorry. That one was 11 hours. So the Gerald Radford was 11 hours. All right, so that's 2 that have gone on longer. All right. Lori Daybell. Joe, you remember that. Lori Daybell. That was 2 hours and 25 minutes. That was Charles. That was the first one. Massachusetts versus Turek. Remember him? I don't have how long that one took. Oh, Michigan versus Schur. Remember him? He was the officer that unfortunately took the life. That was hung. That was a hung jury. That was about 4 hours. Carlos Dominguez, that one was long. Carlos Dominguez was multiple days. Newton, you remember Carlos? You were there. They were there for 9 days. Yeah, they were there for 9 days. Like 7. Yeah, they were there for a long time. All right. Brandon Boudreau, Lori was 30 minutes. Joe, you remember that. Brandon Boudreau's trial, Lori Daybell was only 30 minutes. Took them 30 minutes to come back. Sunny Bell. What was Sunny Bell? Wow, Sunny Bell was 14 hours? Wow. Sunny Bell was 14 hours. Is that right? I guess Sunny Bell was 14 hours. All right, I'm wrong. I guess we have gone through some really long trials. Charlie and Donna were 3 hours. Yeah, we've looked that up before. 1 day of trial, 1 hour of deliberation. Newton, they'll be able to deliberate if it comes down to it on Fridays as well. Yeah, because they were off. They were not in on Fridays. Well, last Friday was Juneteenth, but it was a federal holiday. So, okay, I guess we did have some pretty long trials. Raul Valle was 5 hours and 45 minutes. Is that right? Hold on. Oh, no, wait. Raul was longer. Raul was 3 days, day 11, 12, and 13. So Raul was pretty long. That was 6 hours, 6.5 hours, and 4.5 hours. All right. Here I thought that we did nothing but short trials, but no, verdicts. Cooper, she was, that was 3 hours, 45 minutes. Oh, the Ollies. Remember the Ollies? Doherty was only 90 minutes. Casotis, how long was Casotis? Casotis was 1 hour and 12 minutes. Nick Casotis, remember him? Georgia versus Casotis. Oh, here's Donna. Donna was 3 hours and 17 minutes. I think Charlie was around the same, right? Charlie was around 3 hours or something. So Donna Adelson was 3 hours, 17 minutes. Jose Soto Escalara, he was 1 hour and 12 minutes. That was a DP. He was 1 hour and 12 minutes. They came back really quick. Let's see what else. Bianca Ellis. What was she? She was 1 hour and 12 minutes. Does that sound about right? Daisy Link. Remember Daisy Link? She was 1 hour and 36 minutes. Dustin Duran, he was 2.5 hours. So we have had some pretty long trials. So Colin Gray, how long was Colin Gray? See, now Colin Gray he was 9 days, and he was guilty in under 2 hours. Corey Richins, see, Corey was under 3 hours, and that was 15 days. So Corey was 2 hours and 56 minutes. So she was under 3 hours, and that was 15 days. Well, actually, I'm sorry, that was 13 days. 13 days, but she was under 3 hours. So what else? Kelsey Fitzsimmons. Not sure how long that took. Oh, because we were kicked offline. So anyway, yeah, some of them take a long time. Angelina, thank you so much for your $4.99. Appreciate that. You don't sleep through a firearm explosion on the same bed. Plus, you would have red on you. I agree. JPC, we did not cover Melody. Let's see, how long was that trial? How long did the jury take to deliberate for Melody Ferris? Melody Ferris. Yeah, we did not cover that case. It says they deliberated for over 3 days, totaling more than 15 hours. So 15 hours, over 15 hours for her. So Melody Ferris, right? Melody Ferris was over 3 days, 15 hours. So but yeah, Angelina, I agree with you. He says he's the only one. No, he says he would wake himself up, or he's the only one that could wake himself up when he was passed out drunk. Yeah, I mean, I didn't buy his story. I did not buy his story. Kathy, that was the Melody Ferris. That was over 15 hours. So let's see. DC says for $20, the Alaska court system will send you the entire audio. And so what is that? JMS, jury's waiting for their baked Alaska for dessert. DC says, fun fact about Alaska state courts have never had official stenographers. Since statehood, all court proceedings have been recorded. Interesting. Summer Dog, what was Sarah Boone? I was there, I should know. But I think it was a couple hours. It was a couple hours, let me see. Sarah Boone, I think it was like 3 hours. What was it? 90 minutes, so an hour and a half. So hour and a half for Ms. Boone. I remember I was eating pizza and I just had called Scott and I was sitting there with one of the camera operators from Spectrum News and we were hanging out and I called Scott and I got Scott put me on and it was fun. It was fun. Melanie Ferris, that was another burn pit one. Joy, we didn't cover that. I'm sure other people can talk about it. That was she put her husband, I think, in a burn pit, something like that. Miss Bree, what's the jury? Hold up, I don't know. Haven't been on that much, traveling from North Carolina to New York. Do not know. Nanny to one. I wonder if the defense is still hanging out in case of questions. Shandy says his not remembering anything important, even if he was wasted, excuse doesn't work. In the morning, when he didn't remember where it was or the blood was on himself, don't remember things can hurt him. Grampy, thank you so much for the 5 Trial TV Live gifted membership. Summer Dog got one. Newton Ward got one. Baby Card King got one. Oh my God, Nanny got one and Law got one. Grampy, you just literally got a gifted membership for everybody. Everybody in our chat just got a gifted membership. That is awesome. Grampy, I got to take a screenshot of that. That has never happened before. That is just absolutely brilliant, my friend. That is so cool. Oh, shoot. Here, wait. I got to get a screenshot of that. I don't think that has ever happened to us before. Grampy, you literally got everybody that is in chat. I love it. I love when that happens. That is so cool. That's like a poster right there. That is so cool. Thank you, Grampy. And hey, everybody, Nanny to 1, Law PhD, BB Card King, Newton Ward, Fantastic Summer Dog. Everybody, you guys just became, that is so cool. I love that. Yeah, Kaylee, he planned it that way. That has never happened before. That has never happened before. That is so cool. Angelina says, notable jury deliberations 2003 in California is 55 days to acquit 3 former police officers. Wow. Well, that's quite a lot. Kelsey, how do you get gifted a membership? Been here years, never got one. Make sure your gifts are on. I think we have a prompt for that. I think what is it? What's the prompt? I know Aaron will, I think it's memberships or something. Is it members? Is that it? I'm not sure if that's it or not. But there it is. Yeah. Oh, no, wait. Oh, no, that's commands. You have to have your memberships on. You have to have memberships on. Amber, wish we could all be a fly on the wall in the jury room. Oh, Aaron has to do it manually. Okay. Sorry, Aaron. She has to do it manually. Yeah, I know. Don't you guys that haven't gotten one? I get it. It sucks. I hate when, when people that are not in our chat ever get a membership. Then not that I hate it, because it is what it is, but I would prefer that people are active in our chat. Get one. Oh, there it is. Gifts. Is it gifts? All right, it's gifts. All right. Oh, there it is. Do you have gifts enabled? So enable gifts. So if you guys want, I wish when we give memberships that the people that are active in our chat would get one. I wish YouTube would work that way, but that's literally the first time I've ever seen that. Usually, I've seen one where somebody gifts it to themselves. I've seen that before. We've seen that twice. I've seen like 1 or 2 out of like 5, but I've seen people drop 20. Like Barry does that. Barry, you've done that before, where you'll drop 20 gifts, and I'm like, I don't recognize anybody. Which is whatever it is. It is cool, but I wish it was people that are active in our chat. So. Golden dog lover lurking and working. Come on, jury. All right. Maybe YouTube is listening to our complaints. Yeah. Doubt that. Kaylee, that's why we have the Allen charge. Yeah. What is it in with Karen Reed? Remember what was it? You guys remember it? What was it? It's Allen charge, but Boston or Massachusetts had something else. What was it called up there? You guys help me out on my memory. I can't remember what they called it up there. It was called something else up there. Tui? Was it a Tui? No. What did Bev? What did Canoni? What did Judge Canoni read to the send them back? It's not Tui, is it? I'll wait for you guys to answer. Summer Dog, you got one from someone you never watch. What is it? It is, okay, Tui Rodriguez. Thank you, Aaron. So I got the Tui right. The Tui Rodriguez. Tui Rodriguez. Wait, Kathy, what did you get? Hold on. You got one for a tornado channel I only use when threats? Interesting. Tui Rodriguez. The anti-Bev charge. Joanne, that's funny. All right. Kimmel, you got one for a channel you weren't even subscribed to? Yeah, how does that happen? That seems... I've gotten gifted before, but it's a channel that I've I'm subscribed to. I've never gotten a gift from a channel I've never been subscribed to. DC says, if it is a hung jury, the parties will assemble, the judge will thank them and set a date for a new pretrial conference or omnibus hearing. Shannon, hello, welcome in. How are you? All right. All right, and we wait, and we wait, and we wait. Ambi, oh, that's cool. I like that. Thank you, Ambi, for that. That's really cool. What do you call that? And when did you send that? I'm just now seeing that. That was very cool. Debbie is bored. Debbie is bored, so she keeps. She's like, let's go, jury. Let's see. Thank you for that, Ambi. That was cool. Or Amber, I'm sorry, Amber. I like that. I like that rock and roll. Or that guitar. That was cool. I'm just now seeing that. You may have put that up earlier. I'm just now seeing that. All right. We are going to... I know it's not our favorite, but I'm going to play the defense closing. Again, I know it's not our favorite. Don't tar and feather me, but it's watching from Newton's feed, from Newton's camera angle. So let's watch this. Maybe this will summon the jury. Maybe this will summon the jury. We're almost at 8 hours, so maybe this will get the jury. Maybe this will get the jury to come back with the verdict. Heidi, are they 4 hours in? Yeah, let's see. They started 12:30 our time, and it's almost 12:30. It's almost 4. So 3. Yeah. They're going on. What's that? 3.5 hours. Yeah, 3.5 hours today. 4.5 yesterday. 3.5 today. So, Dreamcatcher. Nope. No questions. No questions yet. Nothing. Bupkis. Absolutely nothing. No questions. No playback. No nothing. Absolutely nothing. So, all right. Sarah says, do you think that the state did not prove that he actually deleted her? I mean, maybe they're hung up on the reasonable doubt. Listen, I think he's guilty, but that's just me. I don't know. I don't know what they're... I honestly have no idea. I have no idea what they could be hung up on. Counts 3 and 4 are a no-brainer. He's already admitted that he tampered with evidence in the department, and he put poor Saria down the drain. He's already admitted to that. So counts 3 and 4, done deal. That's the easy one. Move on to the other two. I don't know. All right, DC, thanks for hanging with us. Appreciate it. I think they might be hung up in state of mind. I don't see any evidence. that Saria did this herself, whether it was by accident or on purpose. There's just no evidence that she was upset. She was distraught. There's no way. You guys do this at home. Take a pen, take a pencil, pen, whatever, and use your dominant hand, which in this case was her right hand. We're pretty sure it was her right hand, although that's not confirmed. But let's just assume it was her right hand. And the trajectory was like just left of center, just left of the midline, slightly down, slightly to the left. That's impossible. It's just, and then if it was her left hand, I mean, that's a little bit more. It's a little bit more. You can kind of maybe get like that, but then she was partially covered, so we don't know. When he said he found her partially covered, was that her head, her body, or like what was partially covered? I wish we had found out what was partially covered. I don't see. I honestly do not see one bit of evidence that proves that she did this herself. I just do not see it. So Denise, she was left-handed. That's her dominant hand. Okay, so let's say it was her left hand. It was at least 6 inches away, so 6 inches is about like that. I mean, look at my hand. It's hurting right here. This hurts. I mean, why would you do that? Why, you would, as the medical examiner said, it's temple, mouth, or underneath. I mean, you don't hold a firearm like that, They didn't say, because I think it was too much time had gone by, plus she was in water. Angelina, she was in like 2 feet of water as well on top of it all, so they did not say. They didn't say. Nikki hit her and lied the way he did. Yeah, Kaylee, the hand, wrist, elbow, shoulder, everything. Yeah, it's just a weird. You just wouldn't do that. You just wouldn't do that. Brad says he couldn't see the wound until he pulled back the covers. No idea how to reconcile that with her doing it herself. Yeah, unless she's hiding under the covers and then she does that. I mean, it makes no sense. Makes no sense whatsoever. No sense whatsoever. Debbie, why didn't the state ask her mom what hand she used? Yeah, that would have been a good question. What's her dominant hand? Yeah, that would have been a great question. That would have been a great question, for sure. But they did not. They did not. JMS, maybe they are hung up because he was so drunk at the time. I'm not sure. But as the state and the judge said, in very, very emphatically, that drinking does not absolve you. You cannot say, oopsie, I was drunk, I don't remember. That's not an excuse. It's not a defense. The defense said that often. I think even the judge, I think that was in their. I think that was even in their jury instructions. Stand for the truth. I'm hoping. Thank you, first of all, for the $9.99. Appreciate that. I'm hoping after the verdict, one of the juries talks to a reporter like Nathan Eaton or me to tell us what took so long. No doubt in my mind he's guilty. Yeah, Nate is covering this. East Idaho News is covering this. So, but yeah, it would be nice if one of the jurors talked to us. Let's say, hey, maybe one of the jurors will talk to us. Let's make that happen. What else? All right, I'm going to go get some water because I'm out of water here. I'm going to go ahead and play this. Maybe this will summon the jury to come to a verdict. All right, here we go. I'll be back.
Homicide, suicide, or accident. The evidence in this case has shown that these are the 3 plausible manners of death that could explain how Miss Saria Hildabrand passed away. Homicide, suicide, and accident. At the beginning of this case, I told you, this case involves the tragedy of a young woman's life being lost to an accident and the story of a scared young man. You've now heard all of the evidence in this case, and I submit to you that it is reasonable to believe that Saria's death was an accident. An accident that was not caused by Mr. Hildabrand, but unfortunately by Saria herself. And because there is reasonable doubt in this case about the manner of Saria's death, there is reasonable doubt to every theory of homicide that the government has presented you with. From intentional murder to criminally negligent homicide, there is reasonable doubt about the element of causation. Every one of those theories, murder 1, murder 2, manslaughter, and criminally negligent homicide, all require you to find as a jury that the government has shown through proof beyond a reasonable doubt that Mr. Hildabrand caused the death of Mrs. Hildabrand. And I submit to you, there is doubt about cause because there is doubt about manner. What is reasonable doubt? A reasonable doubt is based on reason and common sense. There are times where common sense is betrayed to trauma, leading to choices that in hindsight are objectively wrong. This is part of the human experience. And you have seen that in this case. What other human experiences have you seen demonstrated throughout this case? Let's talk a little bit about lying. You've seen quite a few lies in this case. You saw Marie, for example, admit that she lied to Mr. Rice. And Marie's motivation to lie at that time was because she wanted to get information. Who else did we see lie? We saw Detective Clark admit that he lies based off his training and experience in the course of this investigation. And the reason Detective Clark lied is to try and get information efficiently. Lies can show a lot of things. What's important is what is the motivation for the lie. The government would have you believe that a lie must be evidence of guilt. I submit to you that lies can mean a lot of things, and they don't always mean guilt. No one here thinks that Marie is guilty of a crime, even though she told a lie to get information. No one believes Detective Clark committed a crime, even though we know he told a lie to try and get information. And I submit to you that the mere fact that Mr. Hildabrand has lied does not mean that he is guilty. What you need to look at is the motivation behind the lie. And that is what this case is about, the fear. In his panic and fear, Zarrius made some mistakes, some abysmal choices. But these choices and mistakes should not be seen as evidence that Zarrius killed his wife. They should be seen as evidence of what they are, evidence of fear. And what was reasonable at the time that Zarrius did the things that you heard him say he did was that fear. I submit to you, you need to look no further than the opinion of the medical examiner, the biased Detective Clark, and the state's closing argument to understand that fear. Fear. So why was Zarrius' fear reasonable? What was Zarrius afraid of? He was afraid of being accused. When he woke up, he did not know what happened the night before. The government wants you to look at a timeline and wants you to believe that Mr. Hildabrand was immediately looking at pornographic materials after he found his wife deceased. But go back and listen to what Mr. Hildabrand actually said. When Mr. Hildabrand woke up, he looked for his phone. He couldn't find it. But Saria's phone was there. Mr. Hildabrand got out of bed, used Saria's phone to call himself. He called himself twice. And those calls were not answered. I submit to you, it is reasonable for a person to call themselves when they can't find their phone. Then what happens? Mr. Hildabrand can't remember what happened the night before. So he goes and he looks in his phone. He can't remember everything he looked at because this happened almost 3 years ago. Because he was still drunk when he woke up. And because what would happen next was a traumatic experience. And I submit to you, use your reason and common sense here. Trauma affects people differently. Trauma affects memories. Trauma affects our ability to recollect and perceive things. The government wants to call Zarrius a coward because he can't remember everything perfectly. I submit to you that just demonstrates the government's bias in this case. Mr. Hildabrand looks through his phone. It's likely that in that process he went on the Bush Company website before he finds Saria. What else does he find when he looks on his phone? He finds the Snapchats, and he knows, uh-oh, I'm busted. And that's what the government wants you to believe is a motivation to kill someone. Snapchat and Instagram photos. But that's not what Zarrius did. Zarrius went to go talk to his wife about these photos to try to make it better. And that is when Zarrius discovered that his wife was deceased in their bed. That is when the panic and the fear hit him. What was the first thing he did? He checked for her pulse. If he had killed her the night before, why would he check her pulse? You would think he would have known that she was deceased. But he checked for her pulse. And then there's panic and there's fear because he doesn't know what happened. What will people think he did? That was a reasonable fear. And Zarrius wanted to protect the people he loved from the pain of having someone that they care about be accused of doing something horrible. Zarrius wanted to protect himself. And Zarrius made objectively bad mistakes trying to do so. Trying to protect the people he loved, trying to protect him. That doesn't make him a killer. So let's talk about what the evidence in this case objectively shows. Let's talk about Dr. Gallagher. I want to talk about Dr. Gallagher's opinion. And I want to talk about why you should not rely upon that opinion in deciding if the manner of death in this case was actually a homicide. So we go back to Dr. Gallagher's testimony. If you recall, the main thing the medical examiner does, a pathologist, is they determine the cause and the manner of death. If you remember, cause is the medical reason for death. Manner is the how. Manner looks at the reasons beyond medicine, circumstances surrounding the cause of death. Cause of death is not in dispute in this case from the pathological perspective. It is undisputable that Saria died from a single gunshot wound to her head. What is in dispute here is the manner of death, the how. How did that gunshot wound happen? And we learned a lot of things from Dr. Gallagher. We learned a lot about pathology. We learned from a pathology textbook. And what we learned from Dr. Gallagher is that there are multiple classifications for manner of death. We have accidental, homicide, suicide, undetermined, and natural causes. And in this case, we learned that the accidental manner of death could include the taking of one's own life unintentionally. Accident can include the unintentional taking of one's own life. We learned that Dr. Gallagher is busy. Yes, he has training. Yes, he has experience, but Dr. Gallagher is a busy guy. We heard he does somewhere around 250 autopsies a year. Think about how many autopsies a day that would come out to in working hours. We heard that his memory is not always the best. He had a hard time recalling a conversation that Dr. Gallagher and I had just a few months ago. Not because he's trying to lie, but because memory fades over time, and Dr. Gallagher is busy. We heard that Dr. Gallagher writes reports. He relies on those reports, which is fair. When you're that busy, you need to be able to document and refer to things. But Dr. Gallagher is so busy that he doesn't have time to correct typos. And as a result, in this case, there was an error in his report. What else did we learn from Dr. Gallagher? Language varies in pathology, at least according to one reliable treatise. And you heard Dr. Gallagher read from the treatise, in this case, into the record. And I want to take you back to some of the things that we learned from Spitz and Fitcher's Medical Legal Investigation of Death, the 5th edition, a textbook on pathology. The terminology most often used to describe the range of fire is as follows: a contact shot, when the weapon is fired with the muzzle in contact with the body. A close range shot, when gun smoke is deposited on the target. And a distant shot, when the muzzle to target distance exceeds the limit in which gun smoke is identifiable on the target. That is the textbook language. And Dr. Gallagher was familiar with the textbook language, although he does not necessarily use it in his practice. He knew what a close range shot was. He told you he doesn't use distance range in his practice, but he knew what a close range shot was. We learned about range of fire from Dr. Gallagher.
And range of fire would be defined as the distance from the muzzle of the gun to the object, correct?
Yeah.
And for a circumstances, a close range shot could be ruled a homicide, correct?
Yes.
Some circumstances, a close range shot could be ruled a suicide.
Yes.
And in some circumstances, a close range shot could be ruled an accident.
Yes.
In some
Fire would be
In some circumstances, a close range shot can be an accident. What else did we learn from Dr. Gallagher? We learned that the distinction between homicide, suicide, or accident may be difficult and sometimes impossible. Certain criteria are used by pathologists to define the manner of death. Among these, evaluation of the range of fire is of the utmost importance. What else did we learn? We learned that accurate assessment of the range of fire requires test firing of the gun with the type of ammunition that was used in the shooting. We learned that the approximate distance from which a close range shot was fired can be evaluated only by test firing the particular weapon using the same type of ammunition as that used in the shooting case under consideration. Why does this matter? Because the evidence shows that Saria died from a close range shot because there was stippling. Gun smoke was deposited in the area around her forehead. We learned from Dr. Gallagher that a major factor of his opinion on Saria's manner of death was his personal assessment of the range of fire.
Do you recall me asking you the question, besides the stippling and your determination that this was an intermediate gunshot wound, what other facts were you relying on to determine that this was a homicide, classified as a homicide? Do you recall that question?
Not particularly, but we, all of our cases are signed out with review of the autopsy findings, toxicology findings, investigative findings, and medical histories that are pertinent. All that's put together before the certification to determine the cause and the manner.
And you recall in that conversation responding to that question, well, certainly like you mentioned, where she was found is certainly an unusual location, but the main finding of a gunshot wound that is further away that an individual holding the gun should be able to accomplish on one's own self is a major factor in the determination of the manner. Do you recall making that statement?
I agree with that statement.
Do you recall me? She was found as...
Range of fire was a major factor in Dr. Gallagher's opinion. But if you recall from Dr. Gallagher's testimony, he based his assessment of range of fire not on a test fire, but on his training and experience, and I'm looking at the sibling. If you recall, he also said that he would defer to a ballistics expert if their opinion was different. If you recall, he estimated that the range of fire in this case was approximately 2 feet. But what did we learn from Ms. Castle, the ballistics expert, the person who actually did test fire? We learned from Ms. Castle that the muzzle to target distance was not contact, up to 12 inches, most likely 6. Saria died from a close range gunshot wound. 6 from not contact to 12 inches to 6 inches from her head. We also learned from Ms. Castle that the gunshot was slightly upward. Why does this matter? Because when it can be next to impossible to distinguish between homicide, suicide, and accident, and determining the range of fire is of the utmost importance. The range of fire in this case matters. And Dr. Gallagher's opinion on matter is not reliable because Dr. Gallagher's opinion on the range of fire was not accurate. Dr. Gallagher has a lot of training and experience, and we learned a lot from him. But we also learned he did not do the muzzle to target distance testing. He did not go to the crime scene alleged by the government. And he came to a manner of death based off an opinion that was not correct. Homicide, suicide, or accident. We cannot rely on Dr. Gallagher to say that this was a homicide. The government wants you to believe this was a homicide. They want you to believe in motive. They want you to believe that Mr. Hildabrand was able to get a gun 6 to 12 inches away from his wife and kill her without leaving a single defensive wound on Mrs. Hildabrand. And let's talk about the circumstances surrounding 2:48 a.m. Let's talk about what led up to that. Let's talk about Mr. Hildabrand. You heard from multiple witnesses, both from the state and the defense, that Mr. Hildabrand is not a violent person. And that was never contradicted. The government could have contradicted that if they had evidence of that, but you are allowed to consider the absence of evidence. So what do we know about Mr. Hildabrand? We have uncontradicted evidence from multiple people in this case that he was not a violent person. In fact, we heard that when he gets upset, he shuts down. Not a single witness ever heard fighting or arguing from that apartment. You heard how officers canvassed the area. You heard some left cards, they get calls back, they knocked on doors, they talked to people. Not a single neighbor heard an argument that night. Or ever. We heard that although Mr. Hildabrand makes mistakes when it comes to cheating, Saria had gotten over those. They were, for the most part, a normal newlywed couple. And on August 6th, 2023 at 12:07 a.m., that was done. Mr. Hildabrand, clearly intoxicated. Saria, happy with him. The government wants you to believe that they went from Plaintiff's Exhibit 297 at 12:07 a.m. to Plaintiff's Exhibit 298 at 12:55 a.m. What did you hear about Zarrius? What do you see? Zarrius was so intoxicated he could not get into the gaslight. The gaslight. He threw up in the Uber. He is sleeping. He threw up getting out of the Uber. He had to get help inside of the apartment. And they want you to believe that by 2:45 a.m., a mere hour and 55 minutes after this nonviolent person turned into a man who was mentally able to form a conscious objective and physically able to take a gun and get himself 6 to 12 inches from Saria's head while she's on her bed and pull the trigger again without leaving a single defensive wound on Saria. In an hour and 55 minutes from that. And they want you to make that determination not on evidence. They want you to believe there was a fight. And that is where the bias comes out. The bias that has permeated this case from the beginning. The bias because of an opinion that Mr. Hildabrand doesn't act like a normal person. What is a normal person? What is a normal circumstance? Was the situation that Mr. Hildabrand was in that morning, was that normal? There simply is not a normal response to what Mr. Hildabrand told you he found on August 6th. You heard the government call Mr. Hildabrand selfish. You've heard them call him a coward, a narcissist, because they don't think he's normal. But think about what was really going on that night. To believe the government's narrative that this could be an intentional homicide, an intentional murder, makes about as much sense as believing that Saria's death was a suicide. Homicide, suicide, and accident. There's no motive for murder. This isn't a suicide, so what does that leave us with? With the evidence in this case with the 6 to 12 inch range of fire, what does that leave us? Accident. And what evidence supports that this could have been an accident? What do we know? We know Saria was awake. She was awake. She was sending text messages to herself. She was taking screenshots on Mr. Hildabrand's phone. And the reason Miss Saria Hildabrand had Mr. Zarrius Hildabrand's phone is because Zarrius was not awake. Because Zarrius keeps his phone on him like any other 21-year-old, glued to their phone. How do you know Zarrius was asleep? Because Saria had his phone. The evidence is clear that Saria had his phone. Saria was the least intoxicated. We heard evidence and testimony that the firearms were not in their normal location. We heard that when the firearm was found, the safety was off. We heard that both Saria and Zarrius used this gun. And we heard that the direction of ejection was up and to the right. And so every time the government has talked to you about what this could have looked like, they want you to think this. I submit to you that this was an accident. Saria had the gun. She went to the bedroom. She was messing around on it and accidentally discharged the firearm. Not intentionally, but accidentally. Up. And to the right. That is what Ms. Castle testified to. And how do you know that Zarrius was asleep when this happened? Well, look at his cell phone records. Look at Saria's cell phone records. Look at the gap in time of movement. On August 6, 2023, in the early morning hours. There is a brief moment after 2:48 where Zarrius' phone moves. What do we hear? Where were Zarrius' pants in the morning? He woke up in his underwear, and his pants were not in the bedroom. They were over by the bathroom, and they were wet. Sir Hildabrand was so drunk he tried to get up and go to the bathroom and couldn't make it. He was so drunk he didn't know what happened to his wife that night. And the absence of any movement on those records in the hours directly after the 911 call show Zarrius was not functioning until he woke up and called himself on his phone, on Saria's phone. Homicide, suicide, or accident. Zarrius told you he didn't know. Zarrius made a lot of mistakes. He did a lot of thoughtless things. But his fear was reasonable. It doesn't make what he did reasonable, but the fear, that was a reasonable fear. And he told you the mistakes he made. And if he was lying to you, don't you think a better lie would be, I didn't do it? It wasn't me? Not, I don't know. He doesn't know because he has no memory. And not a single witness could tell you that they saw who pulled the trigger on that gun. Homicide, suicide, or accident. This case is about reasonable doubt, because this could be an accident. Reasonable doubt isn't based on what normal people do. Reasonable doubt is based on reason and common sense. It is based on the absence of evidence. And so I want to talk a little bit more about juror instruction number 3. There's an old saying that you'll never really understand a man until you walk a mile in their shoes. And in this trial, you have heard from Zarrius. You have heard of his fear and shame. You've observed through this trial a mile of Mr. Hildabrand's mistakes. But none of those mistakes were murder. The fundamental obligation of jurors in a criminal trial is to apply the presumption of innocence and the burden of proof beyond a reasonable doubt. We talked about this in jury selection. We talked about being objective. We talked about taking an oath. And you all did take an oath in this case. And in jury selection, I talked to you a little bit about the different standards we have in law. I didn't talk to you about probable cause, but we've heard about probable cause in this case. Probable cause is the standard that applies when the government wants to get a warrant to search a home. Probable cause. We've heard, when we were doing jury selection, we talked about preponderance of evidence, if you recall that. Preponderance of evidence means more likely than not. 51% chance. Probably. Likely. But it's not enough that you believe a defendant is probably or likely guilty. In jury selection, we talked about clear and convincing evidence, which is more than a preponderance, but lower than beyond a reasonable doubt. We talked about different areas of law that clear and convincing can apply. We talked about how in non-Indian Child Welfare Act cases, clear and convincing evidence is what is required for the government to show before they can terminate the legal relationship between a parent and a child. It requires strong probability. And we know that reasonable doubt requires more. It is not enough that you believe a defendant is probably or likely guilty, or even that the evidence shows a strong probability of guilt. The law requires more. And there's just not more here. Homicide, suicide, or an accident. Those are the three plausible manners of death in this case. And Saria's death could have been the result of a self-inflicted accident. It's a reasonable inference to draw from this case. Don't get distracted by the emotion. Mr. Hildabrand simply asks that you do what you said you would do at the beginning of this case. When you took your juror oath. I ask that you be objective. Don't let your emotion distract you from the doubt in this case. Mr. Hildabrand made mistakes, and he owned those mistakes in front of you. Those mistakes don't make murder. Objectively, the government has not shown their case through proof beyond a reasonable doubt. And that is why we ask, when you go back and deliberate, to take your time. There is only one verdict that should be returned in this case, and that is not guilty on every count. Thank you.
Ms. Dunlop?
Yes, sir.
The defendant would have you believe that this case is about a series of just unfortunate choices and mistakes. What a belittling and trivializing way to think about this. The defendant cheated on his wife. He got drunk. He got caught. He pulled a gun on her. He pulled the trigger 6 to 12 inches from her head. And then he cleaned up the apartment. He searched porn. He drove all over town getting cleaning supplies in a 96-gallon garbage can. And then he dumped her body in a storm drain. And then he reported her missing and walked through the woods with her mother searching for her. These are not choices and mistakes. These are evidence of intent, evidence of intentional murder. To say that he did not know what happened, it is frankly what he has to say because he's caught on video all over town, right? Like, we know that there's only 2 people in that apartment, no matter how many people Ms. Brewster asked if they heard or saw the gun being fired. We know there's only 2 people in that apartment. To say he didn't know is unreasonable. First of all, it's not a defense. Like I talked about, you can do things in the moment and not remember them later. And if you meant them in the moment, you're still responsible. And that, at best, gets him to murder in the 2nd degree. But that's not what happened. It is unreasonable to think that a 9mm weapon went off inches from his head and he didn't hear it. The neighbor across the courtyard is calling it in, but he didn't wake up to this tragic accident. That's just not what happened. It's not reasonable. Ms. Brewster has said many, many times there's no evidence of a confrontation, that they fought about this. You don't have to have a loud yelling fight to have a confrontation. There's no evidence that Saria was a loud yelling person. The evidence of the confrontation is the messages on Snapchat that she clearly sent to herself, the evidence of the second woman that she, for all we know, didn't know about before she saw the Instagram messages, and the bullet in her head. That's the evidence of the confrontation. So let's talk about whether this is an accident, whether Saria just handled this gun and accidentally shot herself in the head. There's no evidence at all that she ever handled the gun. Zero. The only evidence we have is the defendant says she's fired it before. We don't have her DNA on the gun. We tested it. Nobody's ever seen her other than him with it. There's no evidence that she ever handled the gun. We also know she's not terribly drunk. Why would she be playing with it? Why would she pick up this gun in that moment? No rational reason for it. What we do know is that guns are on the defendant's mind. He's searching them all day that day before they go out, all kinds of different armors. He's looking at Springfield XDs, and he's looking at this particular gun manufacturer at 3:42 in the afternoon. Guns are on his drunk mind. He's the one that has it in his hand. And she's trained and professionally trained in handgun usage. The idea that she would have this kind of accident doesn't make sense. And his response to it is the main thing that proves it wasn't an accident. If it was an accident, you don't think, man, people are going to think the worst of me and think that I did it. That makes no sense. It's not that he's not normal, he's not reasonable. And that's what reasonable doubt comes down to, right? We're going to put 12 of your heads together, use your common sense and your reason, what you know about the way the world works, and say, is this explanation reasonable? And if it's not, you do not have a reasonable doubt. It's not reasonable to think it was an accident that he slept through and woke up to in the morning. And then the final thing I want to address, because this is really an important evidentiary point that is just grossly misstated, is the Dr. Gallagher-Samantha Castle testimony. When the defense talks about the ejection pattern, that's the pattern of the shell casing leaving the gun. That is up and to the right. That is different than the trajectory of the bullet into her head. The trajectory of the bullet into her head is what the medical examiner looks at. And the medical examiner looked at that and he found that it was front to back and minimally upward. And I'm not going to show the photo again, but you can look at it. You can see where it goes in and where it partially exits. It's front to back and just ever so slightly minimally upward. And it's on the left-hand side of her head. Right and upwards is the ejection pattern of the casing, and that's the ballistics expert's testimony. And you really have to listen to the medical expert and the ballistics expert together. It's what the cross-examination was all about, right? Like, this is your opinion, doctor, but would you defer to a ballistics expert who did muzzle-to-target distance testing? And he said yes. So in his experience, he's like, looking at 200 dead bodies a year, we can discredit that and say he's really busy, too busy to do a good job, or we can say, man, he's really experienced and has seen a lot of suspicious deaths. And he has, to a high degree of medical certainty, have to classify that death as homicide, suicide, accident, natural causes, or undetermined. Undetermined is an option he can choose and does choose. And he said homicide. And he said homicide because this is unlikely to be self-inflicted because of the distance. Just like Detective Clark said, he's responded to hundreds of suicides, and there is always a contact wound, and this wasn't a contact wound. And it wasn't a close contact either. It is 6 to 12 inches out. Now, the medical examiner might on his own put it a little further out than the ballistics expert, up to 2 feet. He said intermediate range, up to 2 feet. But he said, I would defer to the ballistics expert. And then the ballistics expert does her testing, and she says, yep, 6 to 12 inches. And when I heard that this might be self-inflicted, I tried to see if I could do that, and I couldn't. Like, she couldn't possibly hold the frame and pull the trigger in a comfortable way for it to be self-inflicted, to be front to back, slightly upward with her dominant hand or with her non-dominant hand. The only way you get that is maybe by thumbs. But like, why? Why would Saria be doing that? That isn't reasonable. There's no evidence she ever touched that gun at all. The defendant is searching and thinking about that gun before they even go out. It is on his mind, not her mind. He is the one that was caught cheating. He is the one that cleaned up and grossly handled Saria's body and dumped her in a storm drain and searched the woods with her mom, pretending that she was missing because he was afraid. Because he was afraid that he would get caught, not because he was sad about some tragic accident that befell his wife, but because he acted on a drunken impulse when he was backed into a corner. Ladies and gentlemen, that is murder in the first degree. It is not an accident. It is not a series of poor choices and mistakes. It is intentional murder. It is extremely reckless murder, murder in the second degree, and it is 2 counts of tampering with evidence. Thank you for your time and attention, and I recognize that this is a difficult case to work through as far as the facts and the evidence and the trauma of what happened. Objection.
Overruled.
But the state trusts that you are all going to go back into that jury room and use your common sense and reason and think about what a reasonable person would do in this situation. Evaluate all of the testimony, the medical testimony, the expert testimony, and most critically, the defendant's testimony, and find that he's guilty of all the counts charged.
All right. We are coming up on almost 9 hours. Coming up on almost 9 hours here. Still no verdict.
And Mr. Howery, can
All right. We'll get to this testimony in a second. But yeah, so 9 hours, 8 hours, 48 minutes. And I was reviewing the jury instructions. It was specifically about the lesser includeds. And count 1 is that it was murder in first degree. Second, count 2 was extreme indifference. Extreme indifference. And then count 3 was tampering with evidence in the apartment. So that's clean up, putting Saria in the 96-gallon can. Count 4 was actually taking her to the drain pipe. So the lesser includeds were second degree, manslaughter, and criminally negligent homicide. But you can only go with the lesser if all are not guilty on the first degree, which is the greater offense. Roger and Riker, I think. So, thank you for that, AWOL. Appreciate that. This channel does real journalism with trials. I truly hope we are here for justice and not soap operas. I don't forget what got you to the dance. Appreciate that. Thank you, AWOL. Appreciate your support and becoming a Rabbit Ears member. Really appreciate that. Thank you. It's always good to see you in chat. All right, so yeah, I'm looking back at the jury instructions, and maybe we can review those. Let's review those, actually. Let's do that now. This will be from the Zoom, so for those that aren't fans of the Zoom, this is from that. But I want to hear the jury instructions, and those were yesterday. Let's listen to the jury instructions. All right, again, this is from yesterday. This is the Zoom. So if it's, I'm not going to listen to all of it. I just want to listen to a little bit of it. And specifically,
I will not read all the instructions that I've already read to you.
Specifically, what he talks about the lesser included. These are the charges. Let's listen to the charges. I mean, I don't even have to show it, but hold on a sec. Hello, Super Ball. Yeah, I know. Keep it moving, dude. Keep it moving. All right. Let me see here. Don't step on that. Please don't step on that. Okay. Keep it moving. Good girl.
But I will reread instruction number 3. I'll start with 15. The evidence has now been presented to you. I will now instruct you on the law to be applied to this case. Then moving back to 3. The fundamental obligation of jurors in a criminal trial is to apply the presumption of innocence and the burden of proof beyond a reasonable doubt. A defendant, although accused of a crime, begins the trial with
jury
clean slate,
instructions.
with no evidence favoring conviction. The presumption of innocence means that you must presume the defendant is innocent of the crimes charged. The presumption of innocence alone is sufficient for you to find the defendant not guilty. To overcome the presumption of innocence, the prosecution must prove every element of the crimes charged beyond a reasonable doubt. This requirement that the prosecution must prove the defendant's guilt beyond a reasonable doubt is called the burden of proof. The prosecution always has proving the defendant guilty beyond a reasonable doubt. This burden never shifts throughout the trial. The defendant is not required to prove his innocence or produce any evidence at all. Although the defendant is never required to produce any evidence, he may rely on evidence brought out through any witness, regardless of which party called the witness. The defendant has an absolute right not to testify. You must not draw any conclusions against the defendant because if he does not testify, obviously here he did testify. What is a reasonable doubt? It is a doubt in your mind about the defendant's guilt that arises from the evidence presented or from a lack of evidence. A reasonable doubt is based on reason and common sense. The defendant must never be found guilty based on mere suspicion, speculation, or guesswork. What is proof beyond a reasonable doubt? It is the highest level of proof in our legal system. It's not enough that you believe a defendant is probably or likely guilty, or even that the evidence shows a strong probability of guilt. The law requires more. Proof beyond a reasonable doubt is proof that overcomes any reasonable doubt about the defendant's guilt. The prosecution does not prove guilt beyond all possible doubt, for it's rarely possible to prove anything to an absolute certainty. If after careful and impartial consideration of the evidence and the law, you do not have a reasonable doubt, then you must find the defendant guilty. If, on the other hand, you think the prosecution did not prove every element of the offense charged beyond a reasonable doubt, then you must find the defendant not guilty. Then we'll move to instruction 16. You've heard testimony that the defendant made an out-of-court statement. It is for you to decide whether the defendant made the statement, and if so, how much weight to give it. In making those decisions, you should consider all the evidence about
all right, I think it's coming up
statement,
after this,
including the circumstances under which the defendant may have made it. The defendant has testified in this trial. You should judge the testimony of the defendant in the same manner as you judge the testimony of any other witness. I'm going to skip over 18. We'll come back to that. I'll read that to you just before close. So moving to instruction 19. The charging document in this case reads,
All right. So this is the charging document. This is what I want you all to listen to. So this is where he talks about count 1, count 2, count 3, count 4. Then he gets into the lessers. So let's see if there's anything we can hear in here that they might be getting hung up on. All right. So if you guys are able to listen, let's see if is there anything that we can pick up that would get them hung. I'm having a real hard time. But let's see if there's anything we can hear here.
As follows. Count 1, that in the 3rd Judicial District, State of Alaska, on or about August 6, 2023, at or near Anchorage, Zarrius Hildabrand intentionally caused the death of Saria Hildabrand. Count 2, that in the 3rd Judicial District, State of Alaska, on or about August 6, 2023, at or near Anchorage, Zarrius Hildabrand knowingly engaged in conduct that resulted in the death of Saria Hildabrand under circumstances manifesting an extreme indifference to the value of human life. That in the 3rd Judicial District, State of Alaska, on or about August 6, 2023, at or near Anchorage, Zarrius Hildabrand destroyed, mutilated, altered, suppressed, concealed, or removed physical evidence with the intent to impair its veracity or availability in an official proceeding or criminal investigation, to wit, 5210 Mockingbird Lane, number 13. Count 4, that in the 3rd Judicial District, State of Alaska, on or about August 6, 2023, at or near Anchorage, Zarrius Hildabrand destroyed, mutilated, altered, suppressed, concealed, or removed physical evidence with intent to impair its veracity or availability in an official proceeding or criminal investigation, to wit, transporting and hiding of the body of Saria Hildabrand. Zarrius Hildabrand, the defendant in this case, has been charged with the crime of murder in the 1st degree in count 1. To prove that the defendant committed this crime, the state must prove beyond a reasonable doubt each of the following elements. 1, the defendant intended to cause the death of another person, and 2, the defendant caused the death of any person. You have been instructed on the elements of the offense of murder in the 1st degree in count 1. This offense includes, in order, the lesser offenses of murder in the 2nd degree, manslaughter, and criminally negligent.
All right, sorry. Here's the here's the lesser included. So they have to agree. It has to be not guilty on count 1 in order for them to go to the lesser included, 2nd degree, manslaughter, or criminally negligent homicide. So he just went through count 1, 2, 3, and 4. The tampering with evidence, count 3 is the apartment, count 4 is the drain pipe. He admitted to that. The evidence is overwhelming. There's receipts. They've got him on video camera buying things. He admitted to putting Saria's body into the trash can while she was on the bed. He described all of that. He describes how he dumped her into the drain pipe. He described all of that. So counts 3 and 4 are like a no-brainer. So count 1, you would only get to the lesser includeds if they cannot agree. I mean, if they do not guilty on count 1. So that I think that's where they're hung up. I think that it has to be where they're hung up, where they can't agree that he did it versus her doing it. All right, so let's continue listening.
Negligent homicide. Intended to cause the death of another person, and 2, the defendant caused the death of any person. You have been instructed on the elements of the offense of murder in the 1st degree in count 1. This offense includes, in order, the lesser offenses of murder in the 2nd degree, manslaughter, and criminally negligent homicide. I have now instructed you on the elements of these lesser included offenses. The lesser included offense of murder in the 1st degree is murder in the 2nd degree. There are 2 different ways for the state to prove that the defendant committed this crime. Each of these ways requires the state to prove 2 elements beyond a reasonable doubt. The state must prove beyond a reasonable doubt, 1, the defendant intended to cause serious physical injury to another person, and 2, the defendant caused the death of any person, or 1, the defendant knew that his conduct was substantially certain to cause death or serious physical injury to another person, and 2, the defendant caused death of any person. With respect to the crime of murder in the second degree, if you find that the state has proved beyond a reasonable doubt each of the elements in the first set of elements or each of the elements in the second set of elements, then you must find the defendant guilty. On the other hand, if you find that the state has not proved beyond a reasonable doubt each of the elements in the first set of the elements and that the state has not proved beyond a reasonable doubt each of the elements in the second set of elements, then you must find the defendant not guilty. To return a verdict of guilty, each of you individually must find the defendant guilty, but you need not agree among yourselves which of the two sets of elements the state has proved. The lesser included offense of murder in the second.
All right, so, sorry guys. So I got to hear that again.
Degree described in instruction number 22 is to another person, and 2, the defendant caused death of any person. With respect to the crime of murder in the second degree, if you find that the state has proved beyond a reasonable doubt each of the elements in the first set of elements or each of the elements in the second set of elements, then you must find the defendant guilty. On the other hand, if you find that the state has not proved beyond a reasonable doubt each of the elements in the first set of the elements and that the state has not proved beyond a reasonable doubt each of the elements in the second set of elements, then you must find the defendant not guilty. To return a verdict of guilty, each of you individually must find the defendant guilty, but you need not agree among yourselves which of the two sets of elements the state has proved. The lesser included offense of murder in the second degree described in instruction number 22 is manslaughter. To prove that the defendant committed manslaughter, the state must prove beyond a reasonable doubt each of the following elements. 1, the defendant caused the death of another person, and 2, the defendant did so recklessly. The lesser included offense of manslaughter, as described in instruction number 24, is criminally negligent homicide. To prove that the defendant committed criminally negligent homicide, the state must prove beyond a reasonable doubt each of the following elements. 1, the defendant caused the death of another person, and 2, the defendant acted with criminal negligence. You are free to deliberate on the charged offense of murder in the first degree and the lesser included offenses of murder in the second degree, manslaughter, and negligent homicide in any order you wish. But you are not to return a verdict on any lesser included offense unless you have already reached a unanimous verdict of not guilty as to the greater offense. The availability of alternative verdicts for lesser included offenses is not intended to relieve you of your obligation to reach a verdict based on the law and the evidence. If the evidence warrants a verdict of guilty as to the greater offense, you must return such a verdict without being influenced by your ability to find a lesser verdict. Similarly, if the evidence warrants a verdict of not guilty to any offense, you must return such a verdict without being influenced by your ability to find a lesser verdict. Zarrius Hildabrand, the defendant in this case, has been charged with the crime of murder in the second degree in count 2. To prove that the defendant committed this crime, the state must prove beyond a reasonable doubt each of the following elements. 1, the defendant's conduct caused the death of another person. The defendant knowingly engaged in this conduct. And 3, the conduct was performed under circumstances manifesting an extreme indifference to the value of human life. Extreme indifference to the value of human life means extreme recklessness. Recklessly is defined in instruction number 29. In deciding whether the defendant's conduct manifested extreme indifference to the value of human life, you must consider the following factors. A, the social utility of the defendant's conduct. B, the magnitude of the risk the defendant's conduct created, including both the nature of harm that was foreseeable by the defendant and the likelihood that the defendant's conduct would cause that harm. C, the defendant's knowledge of the risk. And D, the precautions the defendant took to minimize the risk. Zarrius Hildabrand, the defendant in this case, has been charged with the crime of tampering with physical evidence in the first degree in counts 3 and 4. To prove that the defendant committed this crime, the state must prove beyond a reasonable doubt each of the following elements. 1, the defendant knowingly destroyed, mutilated, altered, suppressed, concealed, or removed physical evidence. And 2, the defendant did so with the intent to impair the physical evidence.
See, now this is where I'm saying this is a no-brainer. He admitted that he did all of this with the tampering. The tampering of evidence, those counts 3 and 4, that should have been within 5 minutes, right? There's no doubt that he did it, he admitted it, that's a done deal. It's count 1 and 2 that I guess they're getting hung up on.
For severity or availability in an official proceeding or criminal investigation. A person acts intentionally with respect to a result described by a provision of law defining an offense when the person's conscious objective is to cause that result. When intentionally causing a particular result is an element of an offense, the intent need not be the person's only objective. A person acts knowingly with respect to conduct or circumstance described by a provision of law defining an offense when a person is aware that the conduct is of that nature or that the circumstance exists. When knowledge of the existence of a particular fact is an element of the offense, that knowledge is established if a person is aware of a substantial probability of its existence unless the person actually believes that it does not exist. A person who is unaware of conduct or circumstances of which the person would have been aware had that person not been intoxicated acts knowingly with respect to that conduct or circumstance. A person acts recklessly with respect to a result or circumstance described by a provision of law defining an offense when the person is aware of and consciously disregards a substantial and unjustifiable risk that the result will occur or that the circumstance exists. The risk must be of such a nature and degree that disregard of it constitutes a gross deviation from the standard of conduct that a reasonable person would observe in the situation. A person who is unaware of a risk of which the person would have been aware had that person not been intoxicated acts recklessly with respect to that risk. A person acts with criminal negligence with respect to a result or circumstance described by a provision of law defining an offense when the person fails to perceive a substantial unjustifiable risk.
Sorry guys, I'm on another computer and I'm not used to this system here. Camilla, you want to review the last instruction? Which one? I've got sick head right now, you guys. What do you want me to do? Go back to the last instruction? How far back? Which one do you want me to go back to? I'm not really thinking clearly right now, so please tell me what you want me to do. I'm not used to this system. Polly, please get out of my water. Thank you. The one about drinking. The one about drinking. The one about drinking. All right, I'll start here. Let me know if this is where it is.
The defendant's conduct. B, the magnitude of the risk the defendant's conduct created, including both the nature of harm that was foreseeable by the defendant and the likelihood that the defendant's conduct would cause that harm. C, the defendant's knowledge of the risk. And D, the precautions the defendant took to minimize the risk. Zarrius Hildabrand, the defendant in this case, has been charged with the crime of tampering with physical evidence in the first degree in counts 3 and 4. As to the greater offense, you must return such a verdict without being influenced by your ability to find a lesser verdict. Similarly, if the evidence warrants a verdict of not guilty to any offense, you must return such a verdict without being influenced by your ability to find a lesser verdict. Zarrius Hildabrand, the defendant in this case, has been charged with the crime of murder in the second degree in count 2. To prove that the defendant committed this crime, the state must prove beyond a reasonable doubt each of the following elements. 1, the defendant's conduct caused the death of another person. The defendant knowingly engaged in this conduct. And 3, the conduct was performed under circumstances manifesting an extreme indifference to the value of human life. Extreme indifference to the value of human life means extreme recklessness. recklessly is defined in instruction number 29. In deciding whether the defendant's conduct manifested extreme indifference to the value of human life, you must consider the following factors. A, the social utility of the defendant's conduct. B, the magnitude of the risk the defendant's conduct created, including both the nature of harm that was foreseeable by the defendant and the likelihood that the defendant's conduct would cause that harm. C, the defendant's knowledge of the risk. And D, the precautions the defendant took to minimize the risk. Zarrius Hildabrand, the defendant in this case, has been charged with the crime of tampering with physical evidence in the first degree in counts 3 and 4. To prove that the defendant committed this crime, the state must prove beyond a reasonable doubt each of the following elements. 1, the defendant knowingly destroyed, mutilated, altered, suppressed, concealed, or removed physical evidence. And 2, the defendant did so with the intent to impair the...
All right, so I don't know if that was what you wanted to hear specifically, but that's I don't know. I don't know what they're hung up on. I just don't know what they're hung up on. So, all right, I'm going to play. We're going to play this guy's testimony. I forget what his name was, but we're going to feed the cats because they're getting a little rambunctious over here. So let me feed the cats, and then we will we'll come back in a second.
And Mr. Howery,
Please solemnly swear. Or affirm that the testimony you give in this case now before this court is the truth, the whole truth, and nothing but the truth. Please, you can be seated. And if you could please state and spell your first and last name for record.
My name is Toby Howery, spelled Tobyhowry.
and Mr. Howery, can you introduce yourself to the jury? Tell them who you are, where do you work?
My name is Toby Howery. I am a local apprentice electrician working for Raven Electric.
And how long have you done electrician work?
I started in October.
Of this year?
Last
or
year.
2026? Or 25?
Yes, ma'am.
And what did you do before that?
I was in the U.S. Army.
And for how long?
5 years.
And where were you stationed?
I was stationed here on J-Bear and down in Fort Drum, New York.
And what years were you at J-Bear?
The very beginning of 21 till about the, I think it was 2024, the beginning of 2024.
And in 2023, did you have occasion to know Zarrius Hildabrand?
Yes, I did.
How did you know him?
I was his team leader / sergeant.
Okay, and what does that mean?
For a bit there, I was his comrade in a military section or squad, and then later on I got promoted to sergeant, becoming a team leader, and then I was placed as a sergeant above Mr. Hildabrand.
Did you know him very well?
I would say yes.
Okay. Did you know his wife?
Yes.
And did you spend time with them outside of work?
Yes.
Okay. Did you have observations about their relationship?
Yes.
What did you think about it? Or what observations did you make?
They seemed happy. I didn't see any really issues. Besides some things that were said, normal relationship issues, I wouldn't make anything crazy.
Okay. Nothing outside the norm? Okay. How did you find out when his wife had gone missing?
It was that Monday morning of the week. Dalen Gates mentioned to me outside of the building 681 in the parking lot.
Okay. And was Mr. Hildabrand at work that day?
I don't recall.
Okay. And if Mr. Gates mentioned to you at the morning, would it have been Monday or Tuesday?
It would have been a Monday.
Okay. How positive are you about that?
Very.
Okay. And did you interact with Mr. Hildabrand that day?
I think so, yes. I'm pretty sure. We had a, yes.
In what context?
I think we talked. I think that's when I think it's when the search party was going on that afternoon.
Okay, so the day that the search party went on, that's the day that you talked to him?
Yes.
Where did you speak with him?
Outside in the parking lot at the search party.
Okay, did you assist in that search party?
Yes, I did.
Okay. What was your conversation with Mr. Hildabrand like?
Just trying to comfort him, just saying we're gonna find her. It's gonna be, everything's gonna be okay. Everything's gonna work out. We're gonna do what we can.
Okay. What did he say?
I don't recall for word that what he was saying that day. He was just saying, pretty much just crying about it, just saying we're just kind of recalling the situation, saying what happened.
Was this a conversation that happened in a vehicle?
No, this is something out. We were in the parking lot outside of his apartment.
Okay, did you ever have a conversation with him in his vehicle?
Yes, I did.
Okay, when did that occur?
I don't recall the day specifically, but it was when I was taking him to his behavioral health appointment.
Okay, and did the military set up a few of those for him?
Yes.
Okay, and were you, as his first sergeant, tasked with kind of watching him or keeping care of him?
Yes.
Okay, he wasn't required to be with you full-time?
No.
Okay, but you're touching base with him regularly?
Yeah, I would stay with him, drive him to his appointments, make sure if he needed anything, I was there for him as an NCO.
Okay. And when the conversation in the car happened, you said that was on the way to a behavioral health appointment?
Yes, it was.
And what did he say to you in the car?
He kind of broke down crying, saying that he was starting to remember more, and that he was very drunk that night.
Did he say anything about what he had said to APD?
Yes.
What did he say?
Pretty much that he's remembering more than what he told APD, and that he was just crying.
Specifically, did he tell you he told some shit to APD and things are starting to come back to him now?
Yes, ma'am.
Okay, implying that what he had told APD wasn't the truth?
Yeah, I wouldn't say the whole truth.
Okay. And after he was taken into custody, did you have additional conversations or meetings with him?
Yes.
Okay. Did you, do you recall a meeting with him at the Anchorage jail along with another soldier, Roberts?
Yes.
Okay. And did that conversation cause you to go to your command and make a report?
Yes.
Okay. Can you tell the jury about that conversation? What was the setup like?
It was me and Angel Roberts. We wanted to go see Hildabrand and just check up, see how he's doing since he was arrested. And we went there and we talked to him. Obviously trying not to talk about the case. And it was just kind of just trying to keep in touch, just trying to catch up as a just friendly thing. At the end, Angel Roberts was getting ready to leave, and I was saying my goodbyes to Mr. Hildabrand, and Roberts was gone, and the last thing he said was, I asked him if he wanted to say anything to anybody outside, and he said no, but I hope this thing isn't recording because I did what I did.
And what was his demeanor like when he said that to you?
Just kind of plain. Just kind of like just empty, I want to say. Just kind of just staring, if you ever just stared at a wall, kind of like that.
Did that demeanor ever change?
When I look back, yes. Because we would do this funny hand salute when we were both in the military together, and I did that when we were leaving, and I looked back and we were kind of like he was grinning. So
he was grinning?
Yeah. Yes, ma'am.
Did that sit with you in a way?
Yes.
How so?
It kind of bothered me. Not with the grinning and everything like that. It just kind of didn't sit with me right. Could you rephrase the question? I apologize.
Did his facial expression and the words that he said, "I did what I did, I hope this isn't recording, I did what I did," did that bother you enough to bring it to your command?
Yes.
Okay. And Mr. Howery, is this difficult for you?
A little bit.
Okay. You were close friends with Mr. Hildabrand?
Yes.
You continued to have a relationship with him even after he was taken into custody?
Yes.
Why is that?
I don't hate him.
But you thought that statement and that behavior was significant enough that you should tell somebody about it?
Yeah. I don't hate him. I hate his sin. I'll say that.
That's all that I have for you, sir.
Afternoon, Mr. Howery. My name is Lacey Jane Brewster, Mr. Hildabrand's attorney. I just have some follow-up questions.
Absolutely.
So you talked with Ms. Dunlop about a conversation that you had with Mr. Hildabrand starting, was it Wednesday after his 21st birthday in a car?
I knew it was the following week after his 21st birthday. I don't recall the exact day.
Okay. But you recall the day you found out that Saria went missing, correct?
Yes.
And the conversation you had with Mr. Hildabrand in the car, that was
later on. It was not the same day.
And you found out on a Monday, correct? And so the conversation happened on Wednesday after that Monday, correct?
That I talked to him in the conversation in the car, yes.
Okay. And in that conversation, Mr. Hildabrand was crying, correct?
Yes.
And he told you he couldn't believe what happened, correct?
Yes. Yes.
And the exact statement he made to you was, "I'm not going to lie, I was plastered that night, but told some shit to APT, and things are starting to come back to me now." Correct?
Yes, coming back and remember, yes.
Okay. Did he say remember or come back?
I don't recall.
Okay. Do you recall when you made this report to an official that you talked with Ms. Dunlop about back in 2023?
Yes.
And would it refresh your recollection to see a summary of that report, of the report that you made?
Yes.
Okay.
Yes.
refresh your recollection? Okay, thank you. So, sir, having had the opportunity to refresh your recollection, was the exact statement that Mr. Hildabrand made to you was that things are starting to come back to me now? Yes.
Yes.
And come back can mean a few things, fair to say?
Come back, yes.
It doesn't necessarily mean remember. Is that fair to say?
Can you rephrase your question?
Yes. Come back can mean, for example, something is coming back to haunt you as opposed to something is coming back to your memory. Fair to say?
Those both seem the same to me in remembering.
Okay. And do you recall what day you met with Mr. Hildabrand when he was in custody?
I don't recall the exact day. It was the following Friday.
Okay. And do you recall, for example, what you were wearing that day?
Yes.
Okay. Do you recall what the person you were with was wearing?
No.
Okay. And how long did you speak with Mr. Hildabrand?
An hour.
An hour. Do you recall every word from that conversation?
Not every single word, no.
Okay. And what you recall is the statement, I did what I did.
Yes.
Okay. And no one else was there when he told you that, correct?
Yes, because Roberts was walking away and the prison guard was coming to handcuff Mr. Hildabrand to go back to wherever he went, where he came from.
Okay. And was this over the phone or was it?
It was over the prison phone system, so it was like in person with glass, but they has phones on the left that you could talk. That's how you talk to them through the glass.
Was he on the phone when he made the statement, or was he off the phone?
He was on the phone.
And he wasn't smiling when he made that statement, correct?
While I was making it, no.
Thank you. I don't have any further questions, thank you.
You redirect.
Briefly, you were asked what day that conversation took place at the Anchorage Correctional Center. Would it refresh your recollection to look at a report of
Yes.
the conversation you had?
Yes.
Does that refresh your recollection? When do you believe that conversation was?
August 25th.
Okay. Now, the conversation at the Correctional Center is August 25th, 2023?
Yes.
Okay. And so then the conversation in the car where he told you that things are coming back to him, was that after he had already told you a different version of events?
Can you restate the question?
Let me say, had he already told you very clearly what the last time he saw Miss Hildabrand?
Yes.
Okay. And what did he tell you, the first time that he told you that Miss Hildabrand went missing?
The first time, it was she was missing, or first thing I was told was she was going to work, and then that the morning after the birthday party, and she went missing. She was walking to work, and then she just went missing.
Okay. Did he say if she had her phone with her?
He said that she didn't have her phone with her at all.
So at the time he told you that initial story, he told it to you like he did know the details, not like he couldn't remember them, right? Okay.
Yes.
That's all the questions I have.
Thank you, sir. Please sit down.
Sorry, guys. All right. So coming up on 9.5 hours officially. Well, officially by my estimate, my guesstimate, 9 hours and 30 minutes. 9 hours and 30 minutes. So. Full Metal Jackie said, I guessed 30 minutes, most of that for paperwork. Michelle, you guessed 0 to 1 hours. Yes, Shannon and Horse Wolfer are also saying, while we're here, let's all hit the like button if you haven't already. If you hear my voice, please take a moment and hit the like button. We have 259 likes. Let's see if we can get that up to, let's shoot for 270. Can we get to 270? If you have not hit the like button, take a moment. Hit the like button for Super Ball. She's right here. Super Ball is expressing her displeasure for this verdict watch. Please hit the like button. If not for the channel, do it for Super Ball. 260, thank you. We hit 260. Let's see if we can get up to 270. Can we get up to 270? Super Ball, what do you think? Huh? Yeah. What do you think? Yep, thank you. What do you think? Are you okay with this verdict? This verdict watch, I should say. Hit the like. Oh, 274. Awesome. Wow, we went from 260 to 274. Thank you, guys. Appreciate that. Stella, how many hours left? It is 5:30 Eastern, which means it is 1:30. Right, they're 4 hours behind us, so it's 1:30 in Alaska. We're at 280. Let's see if we can get to 300. Can we get to 300 likes? If you are listening and you hear my voice, take a moment. Hit the like button for Super Ball. Right? Super Ball is asking you to hit the like button as well as I am. 281. Let's see if we can get us up to 300 likes. See if we can get up to 300 likes. Maybe that'll get the jury to give us a verdict after 9.5 hours. 286. All right, we're getting up there. We're getting up there. Take a moment. If you are listening in, please hit the like button. So yeah, it is only 1:30. It's only 1:30 in Alaska right now. So the judge said they can go past 4:30. Although yesterday they ended I think a little bit before. 295. Awesome. We have 5 more. 5 more likes. 5 more likes. Who's going to get us over 300? Yeah, yesterday the judge did say that they can go to within the hour. Newton, what does that mean? Talk to me. What does that mean, within the hour? What does that mean, Newton, within the hour? 297. I see 297, 298. Do we actually have a verdict, you guys? Newton, what? Talk to us. Don't tease us. 4 minutes ago, Kathy said over 9 hours of deliberation, not a word from the jury. 300. Thank you, guys. Fantastic. Wow, you guys are awesome. We went from 250, 258, 259 up to 300 likes. 301. Thank you, guys. All right, Newton, Kathy is saying 4 minutes ago, after 9 hours of deliberations, not a word from the jury. Verdict reached? Wait a minute. Kathy just said no verdict. All right, Kathy is posting. Verdict has been reached. All right, we got a verdict. Newton, you were right, within the hour. All right, we have a verdict. Newton saying verdict. All right, verdict is in. Verdict time. All right, we got a verdict. We have a verdict. If you're listening to me, we have a verdict. Verdict has been reached, confirmed by Newton and Kathy. So, two sources who are in the court are saying we have a verdict. So now we have to make sure the stream is okay. All right. Oh, let me shut off the clock. Let me shut the clock off. Let me shut the clock off. All right. We'll say 9.5 hours just to keep it easy, just to keep it simple on my... What? Yes. Clock is stopped. All right. So they ended 5:30. I'm going to just keep it simple. So that was 5 hours. So 9.5 hours. We'll just go with that. 9.5 hours. Just keep it simple. So 9.5 hours. Thank you, Newton. Appreciate that. Thank you. And guys, if you have not subscribed to Newton's channel, please do so. I'll drop his link here. If you guys have not subscribed to Newton Ward, please do so right now. 316 likes. Awesome. You guys are awesome. All right, there's Newton Ward's. Go give him a subscribe. Let's get his numbers up. Newton, where are you at? I think you were in the 300s last time I checked. Where are you right now? 323. All right, let's see if we can get Newton up to 350 subscribers. Let's give Newton some love there. Go give Newton some love. And then come back here. Awesome. Full Metal Jackie has subscribed to your channel. Awesome, awesome. All right. We have two people in the courtroom. Camera operator, and I have said a verdict has been reached. So we're going to go with that. We're going to go with that. Now we have to hope that we get a stream from the court. Now we have to get a stream from the court. All right. Verdict is in. We have camera operator and the channel are also saying a verdict is in. So we're waiting for the feed to kick in from the court. Let me get us over here. Now the judge said it would be about 15 minutes after they talked about a verdict. So the judge said it would be 15 minutes. Stay within 15 minutes. Thank you, Elaine. You just subscribed to Newton as well. Awesome. Shore Life, good to see you. You're watching on your TV, ran in for the verdict results. Awesome. Crazy Mary Joe, I just posted it. I'll post it again. Crazy Mary Joe, here's at Newton Ward. Just I'll post the link again, Kathy, or Crazy Mary Joe. Sorry. All right, here's Newton for those that are wondering. This is Newton Ward. For those that are wondering. All right, so that's Newton Ward's YouTube channel. Definitely go take a moment and give him a sub, if you guys don't mind. Thank you for getting us up to 325 likes. Appreciate that. All right. Now we just need the feed to kick in. From the court. So we're waiting for the feed to kick in from the court. Hopefully the cats won't destroy the house in the meantime. Snowcat says it's not hung if they reached a verdict. Interesting captures. You have been watching most of this trial for you, even though I haven't been chatting, haven't been in the Buster house, but they better show the verdict. Yes. Yes, I agree. I agree. Hey, Margaret. Good timing. Great timing, actually. Great timing. Thank you, Crazy Mary Fitz, for subscribing. K-Girl says, if he's found not guilty, I will riot. Yeah, well, be prepared, you guys. Be prepared. This has been weird. This has been weird. Just be prepared. Don't be surprised. Just that's all I'm saying. Just be prepared for whatever. And we've seen some weird things. Just be prepared. Okay. Yes, Aaron reminded me we are no longer in verdict watch. We are in verdict. We are in a verdict. All right. Now we just have to wait for the feed to kick in. All right. Interesting captures. Saying hello, hello. Thank you, Shannon, for subscribing it to Newton. Appreciate that. The Hawaii trial scarred you. Okay, girl. Right? All right. All I can do is just wait for the feed to kick in, you guys. That's all I can do. Defense and defendant have just walked in. I'm reading the same thing, Snowcat. We're waiting for the feed to kick in, you guys. There's no feed yet. Remember, the judge has to kick in the feed. It's going to be the Zoom. It's not going to be regular camera. It's going to be the Zoom. So we're waiting for the court to kick in the feed. So just have a little patience. Have a little patience while it's up to the court now. Hello, Betty Smith. Good to see you. Thank you. Take a moment to hit the like button if you guys don't mind. Take a moment to hit the like button as you're coming in. We're waiting for the court to actually kick in the feed. So until the court kicks in the feed, we are just waiting. All right. Hopefully, Saria will get some justice, but we will see. Let's see. All right, we're waiting for live court to kick in. It's up to the judge to hit the to do that. The reason that he did that is because the way the cameras are situated, the jury would be shown. So that's why it's not live with the camera angle that Newton Ward is providing. So we have to wait for the judge to kick in the live stream. So we're just waiting for that. Christine, hello to you. Welcome in. Good to see you. Denben, yes, we are well aware. That's why the verdict clock is stopped, and thank you for joining us. And thank you for joining us. We are waiting for live court to kick in. Mama C, the jury had no questions and no notes. No questions and no notes. So we're just waiting for the live feed to kick in. So appreciate you guys coming in. We've got unofficially 9 hours and 34 minutes. I backed it up to about 9.5 hours because verdict, and I let the clock play for like another minute or two. So basically about 9.5 hours. Basically about 9.5 hours. And if you guys are just joining us, we're just waiting for the judge to kick in the Zoom link. Again, it is not streamed. They don't show it from the camera angle that Newton Ward is shooting because there's a jury. Unfortunately, his camera angle is such that it shows the jury box. So, Missy Russell, thank you for 15 months. I wouldn't be anywhere else but here with you all. Thank you so much for that, Missy. And Jennifer, member for 5 months. Awesome. Thank you, guys. Thank you for your support for 15 months and 5 months. Really appreciate that. Thank you so much. Yes, Den Ben, you came in just in time. You came in just in time. Thank you, Missy. Appreciate that. And there's Jennifer, member for 5 months. Appreciate that, you guys. Hey, Denise, good to see you. Welcome in. Grab a seat. We are waiting for the live court to kick in. Judge has to push some buttons for us to get the live feed. So that's what we're waiting for right now. Miss Lori GA, good to see you. Thank you, Jennifer. Appreciate that. Really appreciate that. Thank you so much. Candace, glad I found this channel. Appreciate that. Hellrider, awesome. 10 months. Thank you for your anniversary today. Awesome. Lots of anniversaries today. That's so fantastic. Thank you, guys. Really appreciate that. All right. So remember, he did say it would be about 15 minutes. He said that yesterday. He told everybody be within 15 minutes once a verdict is reached. So he said be within 15 minutes once a verdict is reached. And it was around 5:30 our time. It's been about 15 minutes. So I would expect the judge to kick it in at any point at this point. So we are just waiting for the live court to kick in. '80s music, man. No, man, I was here with you guys. Are you kidding? We were streaming. We were dual streaming today. We're picking up on Blaze Taylor trial out of Tennessee. So we were doing that on the other station. So we were dual streaming. I really did not think that this trial would outlast Blaze Taylor day one, but here we are. He did. Judy, you're not here all the time. What happened with your cat? Polly is fine. She got bit by a pit viper about a month ago now. She's fine. She's got a little scar where she got bit, but she's fine. We're going to take her into the vet Saturday. Thank you for asking. We're taking her into the vet on Saturday, and just for like one final checkup to make sure her liver is okay. Hey, Tucci, how are you? Good to see you. Sky, yes, a verdict has been reached. They've reached a verdict. We're waiting for the live feed to kick in. So verdict has been reached. We're just waiting for the judge to kick in the live feed. So once he does that, we will get you into the courtroom. So we're just waiting for the live feed to kick in. All right. And let me see here. I have two sources, so don't worry. I've got my eyes on both sources, you guys. Don't worry, we're not going to miss anything. If we're a minute or so, or even a second behind, don't worry. I see, Snowcat. I see. Don't worry. Guys, I've got my eyes out. Trust me. I've got my eyes out. I will bring it to you one way or the other. Just everybody just take a chill pill. Don't worry, nothing is being played. You're not going to miss anything. One way or the other, we will bring this to you guys. We will bring this to you, don't worry. I don't have time to put up a poll right now, so sorry. Sorry, Amy, I got my hands full here. Apologize for that. I want to make sure that we get this to you guys. So I got my hands a little bit full right now. Welcome in, Mother of Papillons and Linda Lou. Good to see you. Julia, good to see you as well. Yeah, no, we're on the court feed, you guys. I wish you could see what I'm seeing. I'm literally refreshing this every 2 seconds. The court feed has not kicked in yet. Judge left the bench. They are in a holding pattern waiting for the family, according to Kathy Russin. So the judge has left the bench and we are in a holding pattern. They are waiting for the family. That is according to Kathy Russin. So nothing is going on yet. Everybody just, let's just relax. Everybody take a deep breath. You're not going to miss anything. According to Kathy Russin, the judge left the bench and they are waiting for the family to come in. So, thank you, Lindy Lou, for subscribing to Newton Ward. Appreciate that. Thank you, Sarah Dara. All right, so if they're waiting for the family, so we're just going to relax for a little while until the family gets there. Yes, Misty, there is a verdict, and we are waiting for the live feed to kick in. Let's see, maybe now I can get a poll. Let's see if we can get a quick poll. We can get a quick poll here. What do you think the verdict is? What do you think the verdict is? We'll just go with guilty, not guilty. Simple as that. I'm not even going to add hung because I don't think that's an option. All right, new poll for you guys. All right, hold on. We got a feed. All right, we do have a feed. Just give me a moment. All right. Watch now. I got it. Thanks. Always takes a second or two. All right, we got a new poll for you guys. Guilty or not guilty? Just give it a second. Takes the judge a second or two to kick in. All right. All right. Hopefully this will kick in a minute. Thank you. Interesting captures. Mm-hmm. Okay. Yep. So for those that are just joining us, verdict has come in at 9 hours and 30 minutes unofficially. So the court doesn't start the stream until they're ready to bring the jury in. Debbie, thank you so much for the 5 Trial TV Live gifted memberships. I see some people in there. Laura, Amy. Awesome. Hey, Beck. Welcome in, Beck. Lori GA got one. Evangeline got a subscription. Awesome. Got a membership. Thank you so much. Thank you so much, Debbie. Appreciate that. Welcome in, new members. Want some coffee? Good to see you. All right. And now we wait. And now we wait.
Ready for the jury?
Yes, Judge.
All right. Where is the jury, Anthony asks. I don't know. We'll just have to wait. Hey, Agent 333, good to see you. Want some coffee? It's a wrap for this young man, Shani says. I rule. Debbie's a rock star. Yes, she is. You guys hear something? Yeah, I hear. Sorry, I hear some sound from the. Interesting captures. Thank you for the 5 Trial TV Live gifted memberships. That's so cool. Sarah Dara, you got one. Hey, Margaret got one. Awesome. Welcome in, new members. Welcome in. The pretty chick. Yeah, there's something going on here. Let me play it. There's some noise going on in there. So I don't want to talk over it. I'm sure, I mean, the judge has been doing this. We've been following this for 8 days, 9 days, 10 days now. I'm sure the judge knows what he's doing.
Thank you. Please be seated. Mr. Foreperson, has the jury reached a verdict?
Yes, sir.
Could you please hand the verdict forms to the bailiff? Thank you. Mr. Hildabrand, will you please rise? In the matter of the State of Alaska versus Zarrius Hildabrand, We, the jury, find the defendant Zarrius Hildabrand not guilty of murder in the first degree as charged in count 1. We, the jury, find the defendant Zarrius Hildabrand guilty of a lesser included offense of murder in the second degree as charged in count 1. We, the jury, find the defendant Zarrius Hildabrand guilty of murder in the second degree as charged in count 2. We, the jury, find the defendant Zarrius Hildabrand guilty of tampering with physical evidence as charged in count 3. We, the jury, find the defendant Zarrius Hildabrand guilty of tampering with physical evidence as charged in count 4. Thank you. Does either party wish to have the jury polled?
No.
No, Judge.
All right, thank you. I want to thank all of you for your service. This has been a long trial, a difficult trial in many ways. As I think I've noted before, you all were actively participating. I would keep an eye on you to make sure that everyone's still engaged. And I know that this is a long process, a difficult process, and you all took it very seriously and were active participants, and I appreciate that. I want to thank you on behalf of the court system and the state for your service. You are all excused at this point. Often the attorneys like an opportunity to chat with you. If you're willing to stick around, you do not need to stick around. You're not obligated to do that at all. But if you want to, they may come down and chat with you if you're willing to stick around. I will come down and thank you again and then ask for any feedback that you have for how we can make things work smoother for you. But again, you don't have to stick around for that. So you've all completed your service. You're free to discuss the case at this point. And thank you very much. You're excused. Thank you. Please be seated. As the parties understand, sentencing is put out sometime for a pre-sentence report. I have two potential dates, October 20th at 2 p.m. or October 23rd at 10 a.m. October 20th at 2 p.m. or October 23rd at 10 a.m. And those dates, it doesn't matter that much at this point what date we pick. If it doesn't work for the parties when we get closer, just contact Chambers and we can make sure that it's a date that works for everybody. Is there a preference between those two dates at this point?
Yes, Judge.
And what is that preference?
I think that we will probably need some time for this hearing, for the sentencing. So I would prefer we block off a significant portion time of October 23rd.
Let me take a look if I have anything at this point. I don't think I have a date certain trial at that point, but let me...
The 23rd is a Friday.
Yes.
Okay. Right. So if we start at 10, does that work? And I can block off, what, a 4-hour chunk? 2 hours?
I don't know that 4 will be sufficient, Judge. I imagine there will be a lot of statements in this case.
I don't think we need 4 hours, but I'll defer to the court.
I'll block off the day. I always love desk time when I have a chance to do some work, and so unless something, today we'll start at 10 o'clock and we'll take as long as we need. Does that work?
Yes, Judge.
Okay. And again, if those dates end up not working for people as we get closer to it, just contact Chambers and we'll work on picking a new date. All right. Anything else today? Do either parties intend to go chat with the jurors?
I always like to hear from them, if anybody's stuck around.
I guess so, yes.
Ms. Brewster, I couldn't hear you.
Yes, Judge.
Okay. All right. I'm going to run down there and thank them again, and then I'll get out of your way, and you folks can come down and chat with them. Okay. Thank you all. Off record.
All right, so let's play this. I didn't want to switch right as it was happening. I know some of you were saying switch out, switch out. I did not want to switch over because I did not want to miss it.
We start at 10.
Because if I switched over, we would have missed it. So I didn't want to switch over. So for those that were asking me to switch over, I didn't want to do that. I wanted to watch it live with you guys, and then afterwards we would have missed it. So let's watch it here. We can always watch it in replay here.
Thank you. Please be seated. Mr. Foreperson, has the jury reached a verdict?
Yes, sir.
Could you please hand the verdict forms to Mr. the bailiff? Thank you. Mr. Hildabrand, will you please rise? In the matter of the State of Alaska versus Zarrius Hildabrand, we, the jury, find the defendant Zarrius Hildabrand not guilty of murder in the first degree as charged in count 1. We, the jury, find the defendant Zarrius Hildabrand guilty of a lesser included offense of murder in the second degree as charged in count 1. We, the jury, find the defendant Zarrius Hildabrand guilty of murder in the second degree as charged in count 2. We, the jury, find the defendant Zarrius Hildabrand guilty of tampering with physical evidence as charged in count 3. We, the jury, find the defendant Zarrius Hildabrand guilty of tampering with physical evidence as charged in count 4. Thank you. Does either party wish to have the jury polled?
No.
No, Judge.
All right, thank you. I want to thank all of you for your service. This has been a long trial, a difficult trial in many ways. As I think I've noted before, you all were actively participating. I would keep an eye on you to make sure that everyone's still engaged, and know that this is a long process, a difficult process, and you all took it very seriously and were active participants, and I appreciate that. I want to thank you on behalf of the court system and the state for your service. You are all excused at this point. Often the attorneys like an opportunity to chat with you. If you're willing to stick around, you do not need to stick around. You're not obligated to do that at all. But if you want to, they may come down and chat with you if you're willing to stick around. I will come down and thank you again, and then ask for any feedback that you have or how we can make things work smoother for you. But again, you don't have to stick around for that. So you've all completed your service. You're free to discuss the case at this point. And thank you very much. You're excused. Thank you. Please be seated. As the parties understand, sentencing is put out sometime for a pre-sentence report. I have 2 potential dates, October 20th at 2 p.m. or October 23rd at 10 a.m. October 20th at 2 p.m. or October 23rd at 10 a.m. And those dates, it doesn't matter that much at this point what date we pick. If it doesn't work for the parties when we get closer, just contact Chambers and we can make sure that it's a date that works for everybody. Is there a preference between those 2 dates at this point?
Yes, Judge.
And what is that preference?
I think that we will probably need some time for this hearing, for the sentencing. So I would prefer we block off a significant portion time of October 23rd.
Let me take a look if I have anything at this point. I don't think I have a date certain trial at that point, but let me.
The 23rd is a Friday.
Yes.
Right. So if we start at 10, does that work? And I can block off, what, a 4-hour chunk? 2 hours?
I don't know that 4 will be sufficient, Judge. I imagine there will be a lot of statements in this case.
I don't think we need 4 hours, but I'll defer to the court.
I'll block off the day. I always love desk time when I have a chance to do some work, and so if it unless something, today we'll start at 10 o'clock and we'll take as long as we need. Does that work?
Yes, Judge.
Okay. And again, if those dates end up not working for people as we get closer to it, just contact Chambers and we'll work on picking a new date. All right. Anything else today? Do either parties intend to go chat with the jurors?
I always like to hear from them, if anybody's stuck around.
I guess so, yeah.
Ms. Brewster, I couldn't hear you.
Yes, Judge.
Okay. All right. I'm going to run down there and thank them again, and then I'll get out of your way, and you folks can come down and chat with them. Yeah. Thank you all. Off record.
All right, we'll try to answer some of your questions here. So he got not guilty on count 1. Excuse me, not guilty on count 1. Got the lesser included, which was second degree. So he was guilty on the second degree, which was the lesser included. He was guilty on count 2, guilty on count 3, and guilty on count 4. So, okay, looks like that's looks like that's going to be it. All right, so from what I can see, second degree in Alaska is an unclassified felony that carries a standard sentencing range of 15 to 99 years in prison. So he's looking at least 15, right? Now this is first offense, so there may be some wiggle room there. And then the tampering, disposing of a body is not that. It's like a year, if that. Tampering with evidence, it's not that much. Tampering with evidence is a Class C felony in Alaska. Let's see, penalty. So that's up to 5 years. So he's got 2 5 years, so that's 10 plus the 15. So 25 years. That's up to 5 years. So, we'll see what the judge gives him, and then he might be eligible. I'm not sure what Alaska comes in for as far as eligibility of parole. Why it's going to be till October 23rd, I have no idea. That's a long time, right? We're only in June, July, August, September. It's like 4 months. Maybe the judge has a busy schedule. That's why they would end at 1:30 every day. And then the defense asked for 4. The defense doesn't think 4 hours is sufficient, there's going to be a lot of statements in this case. The defense thinks there's going to be a lot of statements in this case. So, Barry, I wonder if the tampering stuff can go consecutive. Yeah, then there's that. Yeah, it could be. They could be concurrent. Those 5 years times 2, that would be 10 years. It could be concurrent. It could be consecutive. We're not sure. We'll just have to wait to see what the judge. Derek, he'll do the 25 plus. We'll see. We'll see what the judge gives him. Could the judge actually say 99 years? Yeah. I mean, yeah. Yeah. I mean, the judge has his scorecard. It's 15 to 99 years. I mean, that's a huge window. So that's basically 15 to life. I mean, that's basically 15 to life. So we'll see what the judge comes back with. The judge, I would assume, has a scorecard. And Renee, I believe it's a third. So yeah, I'm not sure what, if it's like 75%, 80%. I'm not sure. Debbie, so he can get out at middle age and have a life? He could. He's what, 24 now? He could be out in 10 years. Yeah. Second degree is only 15. Yeah. 15 to 99. Second degree is an unclassified felony that carries a standard sentencing range of 15 to 99. Generally applies when a death occurs without premeditation, but under circumstances that demonstrate an extreme indifference. So they think it was not premeditated. So if a defendant has previously 2 or more serious felonies, then it becomes a minimum of 40 years. So he's a first-time offender. So he's a first-time offender. So he may skate with the 15. I don't know. We'll have to just wait and see. And he's already been in for 3. That's right. Yeah, this happened. Yeah, he's already get time served. You're right. Ben, he already has time served. He absolutely already has time served. So, Tattoo Tech, who's going to defend him? Maybe his parents, can't see anyone else standing up for him. Maybe his brother. They might pull his brother. Remember, his one brother's in prison for SA already, so maybe his other brother, MJ, that he goes on and on about how he feels like he let down MJ. Maybe MJ will show up. I have no idea. Carol, yes, rest in peace, Saria, for sure. Mr. T-Man, thank you. Appreciate that. He needs to do 50 years. Yeah, it's 15 to 99. That's 15 to 9. Will he be parole eligible? Well, I'll ask. Let me see. How much of a 15 to 99? Let me see what they say. Most offenders are eligible for discretionary parole after serving between a third and a half of their sentence. So if he gets 15 years, he could be, a third of that would be 5 years, a half would be 7.5. And he's eligible for parole after a third or a half. It just depends. So, tattooed won't it go to appeal if the judge gives him 99 years? They have a scorecard, as we learned from Florida PI Sam, who is a public and private investigator here in Florida. Judges have a scorecard. They have a scorecard, and they go by it. I'm pretty sure that's the case all over. I'm not 100% sure, but in Florida, they actually have a scorecard, and they go by the scorecard to prevent judges from saying, oh, I'm going to throw the book at you, when in fact the scorecard would only show 15 years. So I would guess that Alaska has that scorecard as well. And then he will, he does have time served. He does have time served. Tattoo, yep. And then Ben, he's got 3 years, right? This is 26, and this happened in 2023. It's almost 3 years to August 2023. So he's got 3 years served because he was arrested within a few days, like 4 days later. So he's got time served. He's got 3 years time served. If he gets 15 years, take off 3 years, that's 12, and then a third would be 4 years served. He could be eligible for parole. That doesn't mean he's going to get it. Just because he's eligible doesn't mean he's going to get it. What he has going for him is first-time offender. I think the disposal of Saria that's pretty bad. That's pretty sick. But he can only get, I think, 5 years for that, unfortunately. So. All right. Dreamcatcher, he will not get 15. I guarantee that. It's Tattoo Tech. Don't take that to heart. I mean, yes, technically, but don't. Plus, then he's got those 5 years and possible 10 years. So don't focus in on that. Don't focus in on that because he's still got either the 5 or 10 years on top of that. So that would add another 10 years. So don't get like hung up on that. I mean, if everything went the way he wanted it to, yeah, but again, there's still that 5 years, 5 times 2, whether it's consecutive or concurrent. So again, don't get hung up on that. He could walk in 4 years. Don't get hung up on that. I think even in a best case scenario, you still have to consider those other 5 years. So don't get hung up on that. Don't lose sleep over that. Is it possible? There's still those 5 years. So where do those 5 years come in? Is it another 5 years on top of that? So that would be 9 years, or is it another 10 years on top of that? That would be 14 years. So again, just don't get too hung up on that. Basu, yeah, first time. Where are you? First time offender. Yep, it was a doozy. That's true. Dreamcatcher saying you're still saying he'll get 40. Yeah. We don't know. We just don't know. We'll have to wait to see. The judge has I'm hoping the judge has a scorecard. The judge will go through first time offender. You got your mitigating circumstances. You got your aggravating factors. Aggravating factors was he threw her away like a piece of garbage. He literally threw her away like a piece of garbage. Aggravating factor, he was drunk and he doesn't remember. Mitigating factors would be first-time offender, or mitigating circumstances, I should say, would be first-time offender. I don't know. There's a lot. There's a lot that still needs to happen, but we will absolutely cover this. It's going to be October 3rd. Let me just take some notes here. So October 3rd. So October 3rd at, hold on a sec, October 3rd, I'm sorry, October 23rd, October 2-3, October 23rd starting at 10. So that's going to be 2 o'clock our time. So 2 o'clock Eastern, and the defense thinks that they're going to need at least 4 hours. She thinks there's going to be a lot of statements, so we'll see. So October 23rd at 10 o'clock local time. That'll be 2 o'clock here on the East Coast. So, all right, you guys. I think that's going to be it. That's going to be it for us. We're going to wrap it up here. Thank you. Really appreciate you guys joining us. Is there any poll? Oh yeah. Well, let me read our poll here. We finalized our poll. We took a couple polls. So let me finalize these. Great voting. Good job, guys. 525 votes. Let me just, all right. 525 votes. All right, so one of the polls was, what will the jury do? Guilty today, 50% of you, so pat yourself on the back if you said that today. I'm sorry, tomorrow, sorry. 50% of you thought guilty tomorrow, 41% of you thought guilty today. So good job there. 6% said hung. I think I said hung. Oh, wait a minute, that was yesterday. I'm sorry, today. Sorry, today. What will happen today? And let me read my notes here. So today, 83% of you thought guilty today. 6% of you thought not guilty. 11% of you thought hung. So you kind of half right. He was found not guilty on one charge and guilty on the other charges. What do you think the verdict will be? 94% of you thought guilty. 6% of you thought not guilty. I didn't even think about lesser included. I have to include that. Moving forward, I have to include lesser includeds. Moving forward, I have to include lesser included. I didn't even consider that. Didn't even think about that. So, all right, you guys. With that, we will say good night. Super Ball is right over here. Hello, Super Ball. Super Ball's right there. Yeah, come say goodbye. Yeah, come say goodbye to everybody. Yeah, it's a good girl. You want to say goodbye? Yeah, it's a good girl. You say goodbye? Yeah, it's a good girl. Sweet girl. Tell us how you really think. What do you think about that verdict? What do you think about that verdict, huh? What do you think about that verdict? Did you agree with that verdict? Not sure if she agrees with that verdict or not. Do you agree with that verdict? Tell us what you think. Meow meow. All right. That's a good girl. Yeah, that's my good girl. Yeah, that's a good girl. All right. Good girl. Yes. Okay. Good girl. All right, you guys. Super Ball's not 100% sure about that verdict. All right. So that's a wrap here. That's a wrap here until October 23rd at 2 o'clock Eastern, 10 o'clock local time. We are picking up on the Blaze Taylor trial. We will be in day 2. I know we're a couple days behind, but we will be in day 2 of Blaze Taylor tomorrow. So join us for that. And really, really appreciate you spending your day with us. We dual stream today. So thank you for being kind to the channel. Our mods did a fantastic job. Aaron always does a fantastic job. So thank you to both our mods and to Aaron. And thank you, Super Ball, for your commentary there at the end. Appreciate your input there at the end. All right, you guys, take care. Have a great evening. Do something really positive for yourself and the world. It always starts with just you and ripples out from there. So make sure you do something positive for yourself, whether it's, petting your cat, petting your dog, petting your horse, your snake, whatever it is, going out, looking at the stars, looking at the sun, the moon, whatever it might be. Don't look at the sun. But you know what I mean. Just go out and do something good, positive for yourself. And we will see you tomorrow for day 2 of Blaze Taylor. All right, guys. Have a wonderful rest of your day, and we will see you tomorrow. Take care. Bye.